Honorable Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All men or persons who stand bound by recognizance or who otherwise have business before this court without fear of shall be heard. God save the Commonwealth and this honorable court. Please be seated.
In 2022, we celebrated the court's historic 300th anniversary right here in Philadelphia. I think it's interesting to note, in its earliest years in Philadelphia, our court actually convened in private residences, and the lower courts met in ale houses. In 1707, the city of Philadelphia constructed the townhouse, a two-story house and market that functioned as the early city hall. The court, our court, conducted its business at the townhouse until 1743, when it moved to its own courtroom in the State House, now Independence Hall. Beginning construction in 1871, it took 30 years to construct this city hall. It was designed in the French Second Empire style by John MacArthur Jr. and Thomas Eustace Walter. Sitting atop the building, as you know, is the bronze statue of William Penn, standing 37 feet tall and weighing 27 tons. Mr. Penn's statue faces northeast and points to a spot where he signed a treaty of friendship with the local Native Americans in 1682. After the official opening in 1877, we became the first tenant in this building, and reporters deemed this to be the most handsome courtroom in the country and concluded that some of the more fastidious lawyers will hereafter take only Supreme Court cases in order that they may practice in this court house. So I hope you have a pleasant experience in this beautiful, beautiful courtroom. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with all your cases, so I ask that you avoid any unnecessary recitation of the facts or procedural history and instead focus on your main issues on which we granted review. Counsel is always welcome to rely on the briefs for particular issues. Please also remember that we do not allow rebuttal. In cases in which we have multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as private counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not intended to trip you up. It just indicates that there are particular issues we want to explore further. While there is no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time I ask that you conclude your argument. Mr. Minner, please call the first case.
Clifford Cole et al. Versus the Department of Environmental Protection and Adelphia Gateway. Representing DEP, Mr. Douglas White. Representing Adelphia, Mr. Andrew Bacchus. Representing Pelley's, Mr. Michael Fiorentino.
Thank you. In this appeal by allowance, we are asked to determine whether Section 717RD1 of the Federal Natural Gas Act preempts Pennsylvania's Environmental Hearing Board from reviewing the approval by the Pennsylvania Department of Environmental Protection of a plan for an interstate pipeline and compressor statement. Welcome.
Thank you, Your Honor. May it please the Court, my name is Douglas White. I have the honor of representing the Commonwealth of Pennsylvania Department of Environmental Protection. With me is co-counsel Andy Bacchus, who represents Adelphia Gateway. While I think we all recognize the issues in this case have a lot of overlapping concerns and interconnected closely, I'll be focusing primarily on the roles of the Department of Environmental Protection and Environmental Hearing Board and why and how the Environmental Hearing Board is preempted from acting in these cases. We are asking this Court to reverse the Commonwealth Court decision below for many reasons, but one of the main reasons is the Environmental Hearing Board is preempted by the Natural Gas Act from being involved in this process because it fails to meet any of the very prescriptive requirements listed by Congress in Section 717 of the Natural Gas Act. The Environmental Hearing Board does not review applications. It does not issue federal authorizations. It does not cooperate with the Federal Energy Regulatory Commission, commonly known as FERC. It does not create the record required by the statute. Therefore, it is preempted from being involved in the permitting process of interstate natural gas pipelines and is not involved. The statute clearly dictates one and only one path for challenges to DEP's permits, and that is to the applicable circuit court, and that's the only way it can be done. So if anyone is attempting to bring the Environmental Hearing Board into this particular type of permit process is violating the Natural Gas Act, as they are fully preempted. The Clean Air Act, through the Air Pollution Control Act, authorizes the Department of Environmental Protection to review applications and issue permits. That is what we do. We've done it consistently. Yes, the Environmental Hearing Board is involved in reviewing some of the permits that we issue. But when Congress specifically preempted the EHB from being involved in this particular type of natural gas pipeline permit, it was quite clear that the circuit court and only the circuit court is the jurisdiction for which to file challenges. For example, if you look at 717N, it requires any state agency involved in natural gas pipeline permitting to cooperate with FERC, which is listed as the lead commission, the lead agency for this type of permitting. It indeed has to issue the Certificate of Public Convenience and Necessity before the process even starts. Once they have done that, the statute allows limited and narrow action by state agencies to be involved. To do that.
Counsel, if I could just follow up on your argument. You agree that the Environmental Hearing Board is part of the regulatory process in the Commonwealth? I
do not, Your Honor.
You do not?
I do not. Not the regulatory process. They are not involved in drafting regulations, issuing regulations, enforcing regulations.
Except the process in Pennsylvania has multiple steps in it, and the Environmental Hearing Board is one such step.
If you're discussing the regulatory process, I would respectfully disagree with you that they are not involved in promulgating the regulations or issuing the permits underneath. They are a separate, completely independent, separate state agency that reviews permits once DEP has finally issued them.
Except the regulation doesn't become final until after 30 days, which is the period of time in which someone has the right to seek review before the Environmental Hearing Board.
The Environmental Hearing Board statute does have provision that permits do not become final, yes. But the federal courts have been quite clear that for purposes of federal jurisdiction, states are not free to decide when they think their permits are final or enough for jurisdiction. It's very clear that the DEP's actions are final. They're applicable to the permittee. The permittee is required to comply with them from day one, and federal courts would have jurisdiction over those permits in this situation.
How do you reconcile that view with what the Third Circuit itself stressed in Bordentown? It seemed to me that the Bordentown panel was at pains to emphasize that the NGA was not meant to displace whatever administrative process the state had set up. And I'm not sure how your argument doesn't contravene that, or are you just asking us to disregard Bordentown?
We're not asking you to disregard Bordentown at all, Your Honor, but we are asking to pay attention to, at the time Bordentown was issued, September 2018, the Third Circuit issued 3 cases within 16 days of each other, all addressing this issue. What was referred to as Riverkeeper 3, Bordentown the next day, Riverkeeper 4. In Riverkeeper 3 and 4, the court specifically mentioned the Berkshire environmental case from Massachusetts. Massachusetts has the same setup as New Jersey, as does New York and Maryland for that matter, an internal group within the environmental state agency which reviews permits before they're issued in final. And the Third Circuit specifically said you cannot use cases like Berkshire Environmental for Massachusetts to apply in Pennsylvania because the Pennsylvania law is different. The EHB is a completely separate independent agency. Massachusetts law is just like New Jersey law. So the court was also saying you can't apply cases like Bordentown in Pennsylvania because the EHB is completely separate independent agency. It is not, as in New Jersey, within the Office of Legal Affairs under the New Jersey DEP in issuing recommendations to the commissioner who then issues a final permit. In New Jersey, once that final permit is issued, it goes directly to the Third Circuit. There is no EHB in New Jersey. Otherwise, it would go to the Aplt Division of Superior Court, which is, I think we all agree, preempted.
That's only because New Jersey has a different process. I mean, our environmental hearing board happens to be independent of the DEP, but I would just ask you the obvious question, so what? I mean, the environmental hearing board is not involved in deciding or hearing a civil action. And that is, to me, the essence of this entire appeal. It's the Commonwealth Court focused on, and Judge Connor focused on, in his decision in the Middle District. So doesn't it make a difference that what we're talking about here before the EHB is not a civil action?
You are absolutely correct. The Commonwealth Court focused on those 2 words out of the entire statute. I would suggest to this court that it does not matter what label we ascribe to proceedings from the Environmental Hearing Board.
How could that be? The statute itself talks about civil actions. I mean, how could we not be focused on what the statute tells us to focus on?
Because the statute prescribes the one and only way to challenge DEP permits, and that is through a civil action in front of the Third Circuit. The civil action definition doesn't the proceeding from the Environmental Hearing Board, no matter what you call it, the Environmental Hearing Board is already preempted. If you look at 717N and the prescriptions for what it takes to be involved in the natural gas pipeline permitting, the EHB is preempted. So no matter what you might call the proceeding from the EHB, it doesn't matter because they're not involved. If you choose to really focus on that, I would direct you to the cases cited in Transco's amicus brief, particularly the U.S. Supreme Court decisions in Sullivan and Delaware Valley, where the U.S. Supreme Court refused to hold that civil action did not include administrative board hearings. It said, interpret civil action according to the intentions of the statute that was designed to effectuate.
Well, how does this statute express an intention that proceedings before an ALJ or an ALJ-like person are civil actions?
This statute in 717RD1 prescribes one and only way to challenge permits, the applicable circuit court via civil action, which makes sense because we all agree proceedings for the circuit court is a civil action. Also, if you look back to 717ND, where it requires the agency acting with the permit to coordinate with the commission to create a consolidated record, and that record shall be used for judicial review. That's the clear language of the statute, directs that. That makes perfect sense with the Third Circuit that does a record review. It makes no sense to drag the Environmental Hearing Board in because you don't think a civil action Environmental Hearing Board, because in front of the Environmental Hearing Board, it's a completely new record. They do a de novo review. They allow evidence and documents that even didn't exist at the time DEP issued the permit. So the record from the EHB is completely and substantially different from the record the statute dictates shall be used for judicial review. So there's no way to harmonize the view that the EHB has jurisdiction with the requirement in 717ND2 that the record shall be used for judicial review, because that's not what they use. It does make perfect sense to harmonize it with Third Circuit, which is exactly what Congress said. The applicable circuit court, through a civil action, uses a record that FERC and the state created, and it goes up to them for review.
Any other questions? Thank you. Oh,
Just
go
one-
ahead.
You obviously then disagree with Judge Connor in his decision in Transcontinental Gas Pipeline.
Yes, we do, Your Honor. We think Judge
Because he agreed with the Commonwealth Court.
He did. We would say he made some of the, in our humble review, some of the same mistakes the Commonwealth Court made. In fact, if you look at his references to the Bordentown case in New Jersey, he said, once New Jersey is finished, there's administrative review. Well, administrative review doesn't exist in New Jersey after he's finished. He clearly didn't fully understand the distinctions between New Jersey law and Pennsylvania law. So, yes, we disagree with that opinion also.
All right. Thank you, sir.
Good morning, Your Honors. May it please the Court, my name is Andy Bacchus, counsel for Appellant Adelphia Gateway. It's my pleasure to be joined this morning with my colleague on the briefs, Pat Nugent. Congress amended the Natural Gas Act in 2005 to bolster its role in establishing a comprehensive national energy policy. Motivated by concerns over energy security and the threat posed by foreign regimes propped up by energy exports, Congress aimed to reduce reliance on foreign sources of energy. The Natural Gas Act establishes uniform rules for natural gas infrastructure to avoid the vagaries of 50 different states and 50 different procedures. The Act subjects final permit decisions under the Clean Air Act to expedited federal court review to prevent what would otherwise be a series of sequential administrative and court appeals that could kill a project with a death by 1,000 cuts. The Commonwealth Court's decision disrupts that uniform framework. The core issue here is whether the Natural Gas Act gives the Environmental Hearing Board jurisdiction equivalent to that of the Third Circuit. It does not, given the pressing national need that Congress sought to address. We ask the Court to overturn the Commonwealth Court's ruling and affirm that the EHB lacks jurisdiction over final DEP decisions for interstate natural gas pipelines governed by the Natural Gas Act.
But the DEP decision is only final if no appeal is taken to the EHB within 30 days.
Under state law, but that's not the test under federal law. Under federal law, interpreting a federal statute, as we see from the U.S. Supreme Court, the context of the federal law matters. And here the context is, under federal law, DEP's decision is final. There's nothing left for DEP to do once it renders a final decision.
Do you disagree with what the Third Circuit wrote in Bordentown to the effect that the NGA, even conceding everything you said about Congress's intent generally, that another intention was to let the state administrative process, whatever that process might be, play out, that it wasn't meant to displace that? Or do you disagree with that interpretation?
I disagree, because once you have a federally final decision, that is your ticket to get into federal court. I think that the challenge here, or the issue here, and we see this in the decision below, is that the Commonwealth Court below looked at the definition of civil action as interpreted under Pennsylvania law. That's not the question. The question here is, what does civil action mean under the Natural Gas Act? That's the question.
Are you maintaining in that regard that whole enormous universe or set of universes that has been set up in the national federal system of ALJs, that those are all civil actions, all that somebody's litigating something in front of some ALJ in some federal agency somewhere? Those are all civil actions, and if you maintain that, how's that an action in law or equity?
That is not what we're saying. What we're saying here is that we need to look at the definition of civil action in the context of the Natural Gas Act, not the Social Security Act, not any of the other federal legislation. And this is what the U.S. Supreme Court says with respect to interpreting federal statutes. You have to look at what that statute. We interpret statutes, not provisions. And here, Congress had to envision 50 different states doing 50 different things. we need to look at the term civil action expansively, not limiting to the provision here. And I think this ties back in with some of the questions that Justice Donahue was raising earlier. What DEP did here was issue a plan approval. This is under the Federal Clean Air Act. And that comes from, there's a provision in the Clean Air Act that defines the state's permitting authority. This is in our brief, but it's 42 U.S.C. 7661, subdivision 4. And the Clean Air Act defines permitting authority to mean the Air Pollution Control Agency authorized by EPA to carry out a permitting program. That is DEP. That is not the Environmental Hearing Board. In fact, EPA does the unusual thing of codifying DEP's regulations under federal law, 40 CFR section 52.2020, where DEP's regulations are set forth under federal law, not the EHB's decisions. And let's also keep in mind that this is a rather unusual case. You have the state arguing preemption, but it's not just DEP. You also have the Environmental Hearing Board below agreed with DEP that they were preempted. And on top of that, we have the Federal Energy Regulatory Commission, which, as we see under the Natural Gas Act, is the lead agency. All roads lead to FERC. And what we see here in the federal authority, and this is in our reproduced record, page 364A, FERC identified the DEP plan approval as the necessary federal authorization. Not an EHB order, but DEP. My friend for the Coles would argue that what the EHB really does is the functional equivalent of issuing a permit. But we have to be honest here. If we're going to be talking about functional equivalence of issuing permits, then we need to say that the EHB is also the functional equivalent of a civil action. But as my friend from DEP pointed out, you don't need to get there, because this issue can be decided on preemption alone, which is that under the Natural Gas Act, the only authority that states have is authority under the Clean Air Act. And here, that authority is given exclusively to DEP, not to the Environmental Hearing Board. And I also want to address a thought about due process here, because this is important. Federal law establishes a direct right of appeal to the Third Circuit. Not only that, on an expedited basis. And federal law provides, and this is under section 717RD3, that if federal law, if the court finds that DEP's decision is inconsistent with federal law, there is an obligation for the court to remand the case back to DEP with a deadline for DEP to decide. This is important because there was a clear avenue for the Coles to appeal directly to federal court, and on top of that, DEP's own regulations, and again, this is in our brief, provide that there is an opportunity for protesters, if they are upset with where DEP might go, to file a protest with DEP before DEP makes a decision.
Counsel, the problem I have with your argument is that it forces us to really either ignore or squint when we're reading the language in section 717 RD1, because what it says is that the circuit shall have original and exclusive jurisdiction over any civil action for the review of an order. Okay. You're asking us to read that as if it says the only way that a review can take place is by way of a civil action, and that's just not what it says. I mean, there is a way to bring the civil action, as you just said. I mean, you bring a civil action by filing a petition or, something of that nature. But this says nothing about what happens when, under the state system, there is another way to conduct a review of the decision of here, the DEP, which is the EHB, which is not in any way, shape, or form a civil action under either Pennsylvania law or, generally speaking, federal law.
Let me respond with two things. First of all, we have to read the full sentence in context. It's not just a civil action, but it's a civil action to review an order of an agency to issue, condition, or deny a permit. The EHB does not issue, condition, or deny permits. They don't. And so we can't get there from that way. But to your point in terms of, is this the only way to read this? The answer is yes, because Congress established a uniform system, understanding that there are 50 states in our country with 50 different ways of doing things. Another way to look at this, and this is not inconsistent with Schneiderwind, the U.S. Supreme Court case, it's like a restaurant that has a fixed menu. You get what's on the menu, and that's all you have, because we have an interlocking scheme in the way it's supposed to work. And let me tease that out a bit, because I think folks need to think about how this works in practice. Let's imagine a scenario in which the EHB process moves forward, and the EHB issues an order that says, for example, DEP, you goofed, you need to rewrite your permit that says this condition. And DEP might think, that's going to impact thousands of other air permits. How does DEP appeal that? Under the Coles theory, presumably DEP has to take that order, then issue a permit, and then appeal its own permit to the Third Circuit. There's a standing issue there. Another way to do it is maybe they say, well, that's where you go to Commonwealth Court. Well, that's what happened in this case here with Adelphia, where Adelphia went to federal court and they said, full faith and credit, you have to follow the Commonwealth Court. So the Natural Gas Act establishes a well-articulated, and by that I mean an interlocking system of procedures, and that's the only procedure that can be followed here.
Except the Commonwealth Court here didn't affirm what the EHB did. The Commonwealth Court here said it was all right to go to the EHB, period. And now the challengers could go to the Third Circuit. I mean, what is your concern with this? The amount of time it takes?
Yes, the amount of time. It's a different record. We already have Third Circuit clear case law that points out that DEP decisions can be challenged there. And so this is a classic case of conflict preemption. You cannot have the same federally final decision subject to appeal in two different spots. That is conflict preemption. We saw this in this own court's Kai's decision in 2003, in which this court found that the state administrative agency law, 2PACS, was in fact preempted because it was inconsistent with federal due process requirements, where federal law did not require a hearing, but state law did. And this court found that under the Supremacy Clause, you have to follow federal law. And this is an important point, because the decision below casts the EHB as some sort of scheme in terms of Pennsylvania's scheme. But the reality is the EHB Act does one thing. It determines whether, under state law, a Pennsylvania decision is final. That's all it does. And we already know from the U.S. Supreme Court that it is not a state's law definition of finality that controls. It is federal law's definition of finality that controls. The reality is that once DEP makes a final decision, that decision is subject to final appeal before the Third Circuit. If I may wrap up, so Congress amended the Natural Gas Act in 2005 to bolster its role in establishing a comprehensive national energy policy. The Clean Air Act establishes that DEP, as the permitting authority, is the only permitting authority. And the U.S. Supreme Court's decision in Martin versus Occupational Health and Safety Review Commission and the Commonwealth Court North American Refractories case demonstrate that DEP, not the EHB, has sole responsibility to interpret and enforce its regulations. That is the opposite, or what the Coles are arguing is the opposite of Congress's intent to streamline the permitting and review necessary for natural gas infrastructure. And let me close on this. This court's holding can be limited when it comes to DEP exercising its federally delegated role in connection with interstate natural gas pipeline projects. DEP's permit decisions are subject to review exclusively before the Third Circuit or not at all. Thank you.
Thank you, counsel. Let's hear from appellees.
Good morning, Chief Justice, Justices of the Court. May it please the Court. My name is Michael D. Fiorentino. I represent the individual appellees in this matter, Cole, West, and the Wirebox and the Shelleys. Your Honor, despite the arguments presented by the appellants, the case today is relatively straightforward. An EHB appeal is available from the air quality plan approval here because Pennsylvania's rights under the Clean Air Act to implement that act are carved out from the general preemption worked by the Natural Gas Act, the NGA, and those rights include the role of the Environmental Hearing Board in Pennsylvania's own state administrative process and scheme. The EHB appeal is not a civil action, and thus the exclusive jurisdiction clause of 717RD1 that counsel has mentioned is not even invoked. This is consistent.
Sorry, counsel, but what
Certainly.
about opposing counsel's argument that SCOTUS has spoken otherwise to that proposition? So the definition of civil action. When Justice Donahue and I were asking him about
Yes.
civil action and whether it encompassed ALJ proceedings or not, law or equity, et cetera.
Correct. Your Honor, I think there's a long tradition. I think this court has ruled that a civil action intends to refer to court actions in courts of record, common law damages, equitable powers. The Environmental Hearing Board is not a court of law. That's set forth in their founding document, the Environmental Hearing Board Act. And I think that the term civil action has been not only defined by this court, but also in federal courts to specify that we're talking about a court of law or equity. And as I indicated in my briefs, you can find some indications of the meaning of civil action even in the context of the Clean Air Act, which is the very act that's being implemented under this plan approval, where they—
With respect to that act,
Certainly.
I ask you, should we take into account considerations of comity at all when we consider whether allowing the prospect of simultaneous appeals before the EHB and the Third Circuit as being in tension, if not open conflict, with the preemptive intentions of the NGA?
Well, Your Honor, I think that the fact that that there's any potential for conflict does not rise to the level of conflict preemption. To get to preemption, we have to set aside the plain language of the statute, which this court has ruled, and in fact the Third Circuit has also ruled, has to be only set aside in a situation where what you see is essentially an absurd result. You have to have either an impossibility that's created by the plain language of the statute or an actual clear absurdity. And our position is that it's not at all absurd to allow the state administrative process to run its course. That's what the Bordentown Court, the Third Circuit itself, which would receive jurisdiction over this case if the court followed the desires of the DEP and Adelphia. But the Third Circuit itself has ruled in Bordentown that state administrative, internal administrative process of a state is not preempted by the Natural Gas Act. And therefore, it's sensible that the Commonwealth Court here adopted that reasoning and independently took a look at plain language and what's required and found that test was not met. It's not at all absurd, and therefore you don't have to set aside the plain language. And the civil action, the Environmental Hearing Board appeal here is just not a civil action. Therefore, you don't apply 717RD1. What you use is 717B, and that portion of the statute is alongside RD1 was part of the natural gas amendments of 2005. And counsel was talking about the fact that there had been concerns that things were taking too long to get interstate pipelines through the system and fully approved. And that's why Congress took up amendments. They cite to this death by 1,000 cuts notion and so forth. And there's testimony in the briefs that are offered and even quoted in one of the early cases from the First Circuit about the concern about sequential appeals, administrative appeals, state court appeals, and federal court appeals. We can't get anything done. That was a FERC staffer. And so what did Congress do? They passed the amendments, but what we don't have from the legislative history is any draft language or discussion between members of Congress that are forming this language of civil action. What we can deduce is that they tried to offer some relief to the industry because they eliminated a significant part of that chain of sequential appeals. They eliminated the federal court appeals at the lower courts, and they eliminated state court appeals. And so they put the language in at 717RD1 as saying civil actions, knowing, based on a plain understanding and a plain language understanding of what a civil action is, it's a court action, that they would still be preserving the administrative appeals that can happen at the state level, and which do happen. So 717B is the carve-out that Congress installed to say that states' rights under the implementation of the Clean Air Act would not be affected by anything in the chapter, in the Natural Gas Act. And that's a broad carve-out. Counsel would like the court to believe that it's a very narrow carve-out, that it only applies to permitting. But in fact, the state of Pennsylvania has broad rights under the Clean Air Act to do what they need to do to implement it, despite the Natural Gas Act. So the preemption that they seek is not there under express preemption because the language says civil action, and that leaves EHB appeals on the table. It's not there under field preemption because there's this explicit provision in the Natural Gas Act 717B, which has the carve-out for state involvement, which we believe is quite broad. And I think you can take into account that the states involved in anywhere from imposing regulations, setting up systems for making sure that the national ambient air quality standards are being met throughout the state. They're called SIP plans that have to be developed by the state. Separate regulations have to come online at the state level to make sure. Yes, ma'am.
Can I ask you to address an argument that your opposing counsel made, which is that the review that takes place in the circuit court has to be a review of the record made before the regulatory agency, here the DEP. And somehow that record becomes transmorphed or otherwise is different after an environmental hearing board review. Is that correct?
It is different, Your Honor. That's correct.
And when that occurs and the record is not what it was before the DEP, does that create a problem when reading this act in context?
We don't believe that it does, Your Honor, and that is because the 717N that was being referred to is a coordination of, essentially it's a process coordination provision of the Act. And when we're talking about an expanded record, that is something that oftentimes the circuit court would seek. The administrative record as it stands without an EHB appeal is very thin. And in fact, as recent as 2013, DEP was arguing in a case, I believe it was Tennessee gas pipeline case, in favor they have put a good bit of the duty of developing that record into the Environmental Hearing Board's hands. So from a state perspective, that's helpful. From the federal court's perspective, it's helpful in making their final decision to have a full record.
But what does the Act require? Does the Act require a record from any particular entity within the state? I mean, that your opposing counsel's argument appears to be that what it means is that it has to be the record before the DEP, not the record before the Environmental Hearing Board.
Well, Your Honor, I think the way it would work in practical terms is that if an environmental hearing board process goes forward and a record is developed there, ultimately a decision is made, the environmental hearing board is going to provide direction to the DEP to take an action. It may be a modification of the plan approval. DEP will then carry out that modification. They will have to take into account the record, the direction from the EHB, and they will issue the new permit. That new permit...
So there is a new DEP record at that point in time?
Correct. It is an expanded record that includes everything that happened in front of the Environmental Hearing Board. And that new record would be what would be sent if, in fact, there were still parties who were dissatisfied and wished to take that action to the to the Third Circuit. They would have that full record from the DEP on that from that remand and that modified permit.
Okay. Do we have any other questions from the court?
I just have one. Under your scenario, would a party be able to take their appeal from DEP directly to the Third Circuit, as well as having the option of taking their appeal to the Environmental Hearing Board?
If they did it in a timely manner, yes. The EHB allows for 30 days, and my understanding, based on the case of Riverkeeper 2, the court indicated that they believe that the federal timeline could either be 4 years or the doctrine of laches. So therefore, you could actually have a full EHB appeal process carried out, potentially get to the end of that, and still have the ability, if dissatisfied with the EHB's decision, to appeal to the Third Circuit, even if no action was required by the DEP. And, Your Honor, that scenario would be, let's say my clients wanted to appeal. We got through the EHB, and the EHB said, well, we're going to deny this. We're going to allow the permit to stand as is. So now DEP doesn't have to take an action. But we would argue that at that point, the availability of appeal to the Third Circuit still exists.
What I'm concerned about is the potential for a dual-tracked appeal, where some litigants may choose to go from DEP directly to Third Circuit, and other litigants may choose that they'd rather go through the EHB and then to the Third Circuit, assuming that timeliness isn't an issue. And doesn't that create an issue within this arena of litigation, where you have a number of decisions and precedents being created by one tract, and then another bowl of cherries being created by another tract? Isn't that really one of the reasons why the federal preemption was set down for this area of concern?
Thank you, Your Honor, for that question. And indeed, when you're talking about matters such as concurrent jurisdiction and preemption, you have to look carefully at what preemption requires in terms of the standard. And what it says essentially is that the federal law, if we look at the conflict preemption prong of that, for example, if you look at the federal law and it states that you must find that there is either an impossibility of carrying out the federal law, or that is the primary prong of that. And so what you say is, well, it's not impossible. Our position would be it's not impossible for potentially in a small number of scenarios for two things to go forward at the same time, but the courts are well equipped to deal with scenarios where there are more than one matter going on. There are preclusion doctrines, there's procedural steps that can be taken, collateral estoppel, for example, but it might not be quite as tidy as necessary as the industry would like, but the fact of the matter is that this is what Congress has given. They have left open the door to administrative review. And if that is not tidy enough, parties who are interested are always free to lobby Congress for a change in the law. But I think we have the law that we have.
Why do you...
I have one more question to follow
surely.
up on that. And kind of what ties into my concern about this dual-track process is that, particularly in this area, we're dealing with environmental issues where we have obviously competing interests with people who want to maybe propagate energy in one way and people who have other environmental concerns. And so doesn't it just make it easier for these cases to go from DEP directly to the Third Circuit so we can get an answer, and either these companies can move on or people will get an answer much more quickly about the status of their environmental concerns?
Your Honor, thank you for that question. I appreciate being able to address sort of the nub of why my clients are here. We believe that the Environmental Hearing Board provides a much greater level of due process. In fact, it's the process that the Pennsylvania General Assembly sought to give the citizens of Pennsylvania when they're dealing with environmental impacts, maybe very serious changes in their quality of life based on a new development that's going to involve pollution. And so they have these rights at the Environmental Hearing Board to develop a record to challenge the assumptions that have been made. And we've seen in case law and in briefs the fact that in Pennsylvania, the DEP is often challenged to do more than simply take in the information that's provided by the applicant, do an analysis of it, but they can't do anything independent. Typically, they don't have the bandwidth for it. And so often, the data that's put forward about the environmental impact, put forward by the applicant, is all that is in the record. And so it's very difficult for people concerned about the environment, maybe something that's going to affect them very directly, to have a chance of prevailing at the Third Circuit on the thin record that they get unless they have their state administrative rights in full.
Counsel, why couldn't the record be developed in the Third Circuit? Let's say the challenge to the DEP reg was brought directly in the Third Circuit. It's a civil action. It is sitting in law or equity. It's an evidentiary proceeding. Why couldn't the record be further developed in the Third Circuit?
Well, Your Honor, my understanding is certainly that when the Third Circuit takes up these cases, they're essentially record review cases. I mean, there could be some instances where the Third Circuit, as an appellate court, might say, we can't work with this, we're going to remand it back down to the state to develop the record. And that doing so, that sort of takes away the whole rationale that we're trying to speed things up.
Well,
we're going back down to the state anyway.
But what you're describing, what occurs in the Third Circuit, is an appellate function. That's not what it is. It's a civil action. It's a court sitting in law or equity. So I don't know, maybe I don't quite understand what this process in the Third Circuit would look like, but certainly if the Third Circuit was uncomfortable with the record that it has before it, what would preclude remanding for further development of the record?
Well, Your Honor, I can only go based on the precedent that I've seen, the cases that have come before the circuit courts under the 717 RD1. There's several here in the Third Circuit, a couple in the Second and the First, and I didn't see in any of those cases where the court said that we're going to now develop a record that's involving evidentiary proceedings and sort of adversarial developing a record in that manner. I haven't seen that.
So what's the standard of review in the Third Circuit? Is it what how do they review what the DEP did? I mean, because what you're talking about now doesn't sound like a civil action at all. It sounds like an appeal to the Third Circuit. I
agree.
Well, but that's not a civil action. That's an appeal.
Correct. That is the language that Congress chose, and I think they chose that language not necessarily to direct the circuit courts to hold a particular kind of proceeding that would be different than any other appeal that would come to them, but I think they did so that there would be an understanding that administrative appeals are not guided or governed by that clause, 717 RD1. If I might just add one thing, I would note that with reference to the other Third Circuit cases, the Riverkeeper 3 and Riverkeeper 4, Riverkeeper 3 comes on September 4th or 5th, And Bordentown, which is the case that the Commonwealth Court here has relied upon, came the following day. And that's the one that says we're not going to mess with the internal administrative process of the states. And then Riverkeeper 4 comes a couple of weeks later, as counsel pointed out. However, that case is noted on the top that it is a non-precedential decision. So it should not be given really any weight by this court. I think the final word on the precedential word on the matter in the Third Circuit would be Bordentown, but for the fact that, as Your Honor mentioned, the transcontinental case, which is a very similar scenario to this, an invocation of 717 RD1 to kick a case out, an appeal out of the Environmental Hearing Board. Middle District of Pennsylvania said, no, we're going to follow Bordentown, or we're going to follow Commonwealth Court in Cole, and we are finding that there is no reasonable likelihood of success on the merits, and therefore we deny the motion for preliminary injunction. The Third Circuit Court, in fairly short order, several months, they took a look at that and they issued a judgment affirming the Middle District Court. Middle District Court said no reasonable likelihood of success that you're going to stop this Environmental Hearing Board case from going forward. And we are still waiting for the opinion of the Third Circuit. But I think this court would be in good company to find that the Environmental Hearing Board appeals should go forward in this case.
But doesn't the Third Circuit send us mixed signals in that compressed time frame that it was doing Bordentown and that was doing the Riverkeeper, and why should we consider this on the basis of which one of their decisions was published or not published, or precedential or non-precedential, given that it's all just for persuasive value for us anyway, since we're not bound by any of it?
It's true, you're not bound by it, but it does offer guidance on an issue of federal law for the court.
I agree. I think all of their decisions offer us important guidance. My question was, I think a moment ago you were saying we should stand on Bordentown and not on Riverkeeper 3 and 4 and presumably 5, because the 4 and 5 at least were unpublished, and so those are lesser value. Why should that seems like a thin reed to stand on, isn't it? I mean, if they're persuasive, they're persuasive. If they're not, they're not.
Well, I think, Your Honor, thank you for the question. I think it gives us an indication, it gives the court an indication of where the Third Circuit sits. If they are going to be the court to take up these appeals to decide whether or not they should be heard, what they've done in the Riverkeeper cases is essentially say, well, you brought a petition to us, so we have jurisdiction under this clause 717 RD1. We'll take the case. But even in Riverkeeper 3, they weren't saying that an EHB appeal would have been denied. And likewise, I think with 4 and 5, they're addressing finality. Was there a final action of the DEP? If it's a final action of the DEP, then the court ostensibly has jurisdiction to hear an appeal from a final action, particularly when you have the language of 717 RD1. So I think that's what the Riverkeeper cases go to primarily, but Bordentown goes to preemption because they analyze the civil action term very carefully and find that it does not include an EHB appeal, allows them to go forward. I don't know if that answered your question, Your Honor.
I think, the Commonwealth Court sort of dabbled around the edges of this also, but, you use the term a final decision or a final order
Final
from
action.
well, I mean, if you're looking at Pennsylvania, if you're looking at our law, it's not final until the 30 days has passed and no appeal has been taken to the EHB. So, and some of these circuit cases actually deal with cases that are appealed within that intervening period, that 30 days.
I believe that is true, Your Honor, but in fact, one of those cases specifically said, you're past the 30 days from the DEP issuing the permit and the 30 days you get under the state law to bring it to EHB. So it's too late for you to go there anyway. We're happy to keep it here at the Third Circuit.
Well, because then it is a final, by the decision of the party who did not appeal it, you have a final order of the DEP at that juncture.
Correct.
Okay.
All right, any other questions? I think you've wrapped up a number of times, I think, in response to the questions. I think we've got it. I thank you, sir.
Thank you very much.
Mr. Fiorentino, did you introduce your
I'm very sorry. Sitting with me is Casey Manahan. She is with the Delaware Riverkeeper Network, one of the environmental amici.
A riverkeeper.
A riverkeeper. All right, thank you.
Thank you.
Thank you all.
Commonwealth of Pennsylvania versus Saunders, representing Mr. Saunders, Ms. Catherine Munns, representing Commonwealth, Mr. Michael Crozer.
Okay, during a traffic stop, appellant misled a police officer about the presence of a firearm in his vehicle. The officer observed the handle of a gun protruding from under appellant's seat, and appellant stated that he did not have a firearms permit. After appellant was frisked and placed in the back of the police car, the officer retrieved a loaded handgun from appellant's vehicle. We accepted review to decide whether the plain view exception to the warrant requirement has been altered by our court's 2020 decision in Commonwealth versus Alexander. You may proceed.
Good morning, Your Honors, and may it please the Court, my name is Catherine Munns with the Defender Association representing Omar Saunders. And I just wanted to remind all of you again before I start, if I rely on lip reading, I'm using the hearing assist device, so if you could speak into your microphones and not cover your mouths when you're speaking, I appreciate it. And I know last time I was a little quiet because I'm coming through really loud. Am I loud enough for you today?
You sound perfect.
Great. This case is about whether probable cause alone allows a police officer to enter a car. In Alexander, this court forcefully and clearly stated that the answer to that question is no. Obtaining a warrant is the default rule. Police need exigent circumstances otherwise. The mobility of a car, or even the fact that the police officer saw the thing that gave rise to probable cause, is not an exigent circumstance. And this is what Alexander ruled, that these must be treated individually. Now, the Commonwealth position would undermine that ruling, and this court should not adopt it. The plain view doctrine, it is often referred to as an exception to the warrant requirement, but really the plain view doctrine is a set of facts that must exist in order for a police officer to pick up an item when he's already inside of a space. So the first requirement is that they are in a position where they can legally observe an item that is, and then the second prong is that it be obviously contraband. And the third prong is that they also have a lawful right of access to the space. And that is because it was envisioned to allow police officers to pick up something that was obviously contraband when they were already inside of the space.
Well, he was looking, the police officer was looking inside, presumably through an open window, and he saw the edge of the gun. Why isn't that a plain view observation?
Well, we agree that he was in a legal vantage point when he observed the firearm, because in this case, what he sees is he looks through the front of the window. I mean, it's all on video, so you can see how he looks through the front window, and what he says is he sees Mr. Saunders actually in the act of secreting it out of view, so he can see it as he's pushing it under the seat. And he says, I didn't think he was trying to pull it out, I just thought he was pushing it under the seat. So the first prong has been met. We haven't argued that. But basically what has happened is the way that Plainview has been treated for car stops has essentially more or less read the third prong out of it. And so we protect privacy in Pennsylvania by protecting spaces. And so while he was in a lawful vantage point when he observed Mr. Saunders pushing a gun underneath the seat, he then entered the car without any exigent circumstances, therefore invading the protected space.
Counsel, is it your position now that Alexander has eradicated any exception to the warrant requirement, that every case now requires probable cause plus exigency?
If the police are doing a search of a car entering the space, they must have exigent circumstances.
Is an unsecured gun in an unsecured vehicle an exigent circumstance of public safety for the police officer to act?
Under some circumstances, it would be. In this case, I would argue that it's not.
And why not?
Okay, because my client was under arrest and placed in handcuffs in a police car. That's the short answer.
So what is the alternate, to leave the car alone, impound the car?
Well, I would say depend on the circumstances of the case. You know, the police, we don't necessarily know how long they were out there. We don't know how long it would have taken them to get a warrant. Part of the problem is that by reading mobility, by treating traffic stops as though the police can never get a warrant, we're not actually requiring them to establish that they couldn't have gotten a warrant.
But, Counselor, let me take your argument to the logical extreme. But you're now saying, I am perceiving you say that without the warrant and without saying the gun in and of itself is an exigent circumstance, that the police officers now can put you in a cop car and just automatically impound every car of every traffic stop, arguing, since they didn't have exigency, they have the right to now take the car and impound it for an inventory search. Aren't we creating a secondary problem as a result of your trying to alleviate this problem?
Well, in a circumstance where there would be a long period of time to wait, or I believe you'll shortly be addressing the inventory search issue, so I know that's a slightly different issue. In the circumstance in which there is a choice between waiting a very long time or having all of these other possibly bad outcomes, one of the options is certainly to ask the individual for consent to search the car. It doesn't mean that any time probable cause arises, they impound the car. It means the warrant is the preferred exception. Now, there might be circumstances in which impounding the car is the only possibility. There might be circumstances in which they can make a quick phone call because they are allowed to get warrants that way, and they can obtain the warrant. They could wait with the car. They could secure the car. There are certainly a lot of possibilities.
Counsel, can I interrupt you on that? I mean, I'm not sure that, you know, I think I'm a little nervous about going down this test of possibilities. Is a search unreasonable because the police could have done X, Y, and Z? I don't think that's the constitutional test. We don't sit here and decide after the fact all of the things that the police officers in the middle of the moment could have done. I mean, you can always get a warrant. You could always stop something and secure a facility and get a warrant. I'm struggling with the search aspect of this. You know, in Alexander was a true search circumstance. Police officer didn't see contraband in plain view, smelled marijuana, did a full vehicle search looking for contraband. These facts are different. The police officer, the door was open to the vehicle after the arrest. The gun was identified in plain view. It's still in plain view with the door open. The suspect admitted that the gun was illegally possessed, and the police officer, under those circumstances, reached in to the vehicle and retrieved the gun. Did not do a search for marijuana or other contraband or search the vehicle for other guns or anything like that. It was a limited intrusion into the space to recover a piece of contraband in plain view. Are you telling me that under those circumstances, your client had a reasonable expectation of privacy that the society deems to be objectively reasonable and protected under the Constitution?
In a car, individuals have a reasonable expectation of privacy under the Pennsylvania Constitution.
Generally speaking, I'm asking you, under these circumstances, these particular circumstances, did your client have a reasonable expectation of privacy that society deems as reasonable, i.e., it was unreasonable for the police officer simply to reach in an open car door and take the gun?
Yes. And the reason for that is because, again, it goes back to the idea of spaces and the threshold, right? That is where we draw the line. If you were talking about a house, for example, you could have a bag of drugs sitting next to a gun in a windowsill with a big sign that says "for sale," and that would be the fullest amount of probable cause that we could have, but it would not justify entering the space. And so, in cars, it is a little. We interact with cars differently, and so the way that.
Well, tell me how you'd have to change your facts a little bit, right? I'd have to be walking down a public sidewalk. There's no property owned between the window and the public right-of-way where the police officer could stand. And there is a bazooka, an operational bazooka, in the window that I can just go up and grab. So I'm standing on public space. I'm not invading your curtilage at all in your hypothetical. I'm standing where I'm allowed to stand. There is a dangerous weapon in a window, and you're saying, hold the phone, society deems it as unreasonable for me as a police officer to protect the public to seize that unreasonable weapon. I need to get a warrant. That is an unreasonable seizure that society would protect.
One of the differences, you're adding in a few facts which start to lead to the development of exigencies. And so I'm not saying in that situation that exigent circumstances would exist, but if you had a circumstance in which there was an imminent danger that was established by the facts, that would justify entering the space. Our argument is that they must be required to develop the explanation of what those exigencies are before they enter the space.
Did this police officer crawl around in the vehicle?
No, he did not.
As he reached into the vehicle, so where the officer was standing was your client didn't have an expectation of privacy in the concrete.
On the sidewalk, you mean?
Wherever the officer was standing when he reached in.
Not where he was standing.
So he was lawfully standing next to the car.
That's right. We haven't challenged the fact that he was in a lawful place when he initially viewed.
So the unlawful place was the hand reach in to retrieve purely the gun.
You know, the Commonwealth has really focused a lot on the minimalness of the minimal intrusion in this case. But the fact of the matter is the plain view doctrine doesn't only address this sort of minimal intrusion. The plain view doctrine addresses the officer's access to the protected space, period. You know, there are lots of circumstances we could imagine where something is seen by a police officer, and then he has to reach his entire body into the car in order to retrieve it, and upon doing that, views all sorts of things that either invade the privacy or discover additional contraband that would then be in plain view. And I think, in fact, in McCree, for example, this court, the officer went to arrest someone, and as he's doing that, he sees him put a pill bottle underneath a seat, no longer in plain view inside the car. But because it was observed in plain view, in that case, it was still treated as being in plain view, even though this was a circumstance in which the individual was actually putting something out of plain view. And in this case also, you know, the area underneath seats, generally something out of the public view, this is a situation in which Mr. Saunders was, by the police officer's description, actually pushing it out of the plain view. And so what it does is it allows intrusion, period. And we draw the line at thresholds because drawing the line at the number of inches the officer intruded or just how far in they went I have a hard time figuring out how that rule would even work. But drawing the line at the threshold is drawing the line at the protected space. And when you enter the protected space, it becomes an invasion of privacy, And maybe there were other things under that seat. Just the fact that it was his hand and not his head doesn't mean that he couldn't have encountered all sorts of things that Mr. Saunders were legitimately protected as private. I believe that under the seat, the area under the seat is actually one of the private, out of public view areas that is listed in Justice Todd's dissenting Gary and quoting Lefebvre, right under the seat, in the trunk, in the different closed compartments. And so right now we have, well, if the area that is in plain view is really close to the door, do we have a different rule? And that's why drawing the line at the threshold is, in our argument, the right way to go, rather than trying to figure out how far into the car the police can go.
Counsel, I get a little bit uncomfortable when we sort of try to pigeonhole this because it's a plain view case. The object in plain view gives you probable cause, period.
Yes.
Period. The fourth factor requires the establishment of the lawful right of access.
Correct.
And the lawful right of access requires to comport with the limited automobile exception in this Commonwealth, whatever that may be. This issue of trying to dissect this because it's a plain view case, I think, loses sight of the fact that all we're really focused on here, because of your concession on the plain view, which I don't understand at all, but that's just a different issue. We have probable cause. What we're focused on is the fourth prong, lawful right of access. What do you need to search an automobile in the Commonwealth of Pennsylvania? Your argument is you have the probable cause, you need an exigency. Am I correct?
That's absolutely it. The requirement for fact-specific exigent circumstances has been essentially read out of the rule by the Superior Court in the way that they treat traffic stops. And it's the only sort of, and you're right, plain view really just describes that probable cause developed because the officer saw it.
Sure.
If when he was questioning my client, Mr. Saunders had said, there's a gun in the seat, I don't have a permit, we wouldn't be talking about plain view at all.
No, you have furtive movement, same thing. I mean, there are other ways that probable cause can develop. In a plain view case, it's because it's in plain view.
It's because probable cause arose based on what he saw rather than something he heard or was told or a whole other host of factors. And so our argument is the fact that probable cause developed based on the officer viewing an item doesn't change the larger requirement for entering the protected space of an automobile.
How about the protected space of a home? Let's say that a firearm is viewed through an open window in a house, and the firearm is, just beyond the windowsill. Nobody in the neighborhood, take out exigencies of, kids could grab it, all those kinds of things. Say it's an abandoned house, but we know who owns it. Can the police just reach in the window in that house and grab the gun?
No.
Why is it any different for a car?
Well, I would argue that it is not. The way that the only real difference between cars and homes under the requirement for probable cause and exigent circumstances is the ways in which exigencies arise.
Counsel, let me follow up Justice Donahue's concern. The question is outside the House with this vehicle. The question before this court is, does this court's holding in Alexander require, quote unquote, a fact-specific assessment to determine whether exigency exists, to provide the officer with access to the interior of the court, legal access under the plain view doctrine? It's easy to distinguish someone's home with a locked door, maybe an open window, as opposed to the facts of this case, a vehicle being on a public street unattended with a visible firearm present. The question I have is, if we grant this question yes, are we not, if we say yes, there is a requirement, a fact-specific requirement to determine exigency, can we review the facts to say an unattended car on a public street And is this North Philadelphia, I believe, which is a populous area? Or is that the next case?
You know what? I don't remember the
Yeah, me
national
either.
neighborhood. I'm not.
But either way, Philadelphia is a populated city with a visible firearm. Does that fact specifically create an exigent circumstance? We're no longer talking about a right of privacy. We're talking about the question that's limited to this court.
In this particular case, I would argue that the Commonwealth would need to do more to develop exigency, because exigency is compelling need for official action and no time to secure a warrant. And the fact of the matter is, there's just no reason to believe the officers couldn't have gotten a warrant.
But again, I'm not sure they always can get a warrant. They can always get it. If they have probable cause, they can always get a warrant. That doesn't, the test of exigency is not, is it impossible to get a warrant? Because it's always possible to get a warrant. The test of exigency has to be something other than they can get a warrant.
So let's say so the kinds of exigencies that arise might be, there's a person who's getting back into the car, right? So that would mean that person would then have access to the firearm. Or say the police are called away and cannot stay with the car. That might be an exigency. But the fact of the matter is, we have a warrant requirement so that the police officers who are part of the executive branch don't just, if probable cause was always, the officer's judgment was always good enough, we wouldn't have a warrant requirement. But we do, and the warrant requirement states that unless there's some reason why the police officer can't do it, can't stay with the car, can't, for whatever reason, there's an actual danger that they've established on the record in that situation, and they need to act soon, then they need to go get a warrant and have it reviewed by the judicial branch. And so, but just saying, we can always game it out after the fact when he did find something, right? And so all of the cases that come to this court are cases where they did find something, and we say, oh, well, the police were right. But you think about all of the cases, in fact, I think I stated in my reply brief, the state police in 2022 had a 53.6% hit rate searching cars. So I think it's a good idea, and they're getting warrants, some 7-something% of the time, in at least that year.
But you don't see a distinction. I mean, getting back to this case, you don't see, the plain view doctrine is a doctrine that allows seizure of something, not just a search. You don't differentiate between a search of an automobile without plain view. In other words, you think this is just the same thing as Alexander. In Alexander, though, they didn't see any contraband. And then Alexander says, in the absence of something else and just smelling marijuana, you cannot search an entire vehicle looking for contraband. You think that paradigm of a full vehicle search, no plain view, is applicable to an absolute, a plain view of what is identified and confirmed by the person as contraband, and going in and getting that contraband, you think that's the equivalent of Alexander?
The plain view doctrine presumes the police are already inside the protected space. And there are a whole host of different types of searches that are more or less invasive. We're not drawing the line based on whether the police are slashing the seats and cutting up. You know what I mean? Like, there are all sorts of, just because they go into the trunk, that's out of bounds. All of the different spaces within the car are out of bounds. We draw the line at the threshold for a reason, because it's the space that is protected. And so the reason that the plain view doctrine is generally treated as addressing possessory interest and not privacy interest is because it presumes they're already inside. And so when you take that out of it, it does implicate privacy interest because it allows the police to enter the protected space. And I think that's what the real difference is. It is no longer just addressing possessory interest, but it addresses privacy interest because the police are going into the protected space.
And you believe that an open car, a car that you have your doors open, windows down, on the street, and you have contraband in plain view as a police officer is walking by, is still a threshold area that objective Pennsylvanians would believe should be protected?
Well, the problem is this car is open on the side of the street, because the police have already changed the situation. Right, so Mr. Saunders driving down the street.
Well, can you answer my hypothetical first, though?
Oh, I'm sorry. I thought you were talking about this case with the doors open.
No, I'm moving there. I'm just trying to understand what your limits are. If I park my car on Broad Street and I open up all the doors and I walk away, and on the seat is a gun, do the police need a warrant to seize that gun because they're crossing the threshold into the vehicle?
I mean, if we're talking about, I can think of some exigencies in that scenario.
But is that, I'm not going to exigency, I'm going to basic Fourth Amendment privacy law. I'm getting really down low on privacy. Have I exhibited a subjective expectation of privacy that society is willing to protect as reasonable?
Not under the Fourth Amendment, under Article 1 and Section 8, because it is a car. But, I mean, somebody who leaves all of the doors and windows open and then walks away leaving an unattended car is certainly treating their car differently than someone in a traffic stop. And so I think that's sort of part of the difference. And the other thing is, it is the development of exigencies that give the officers the right to go in. And so, as with, the Commonwealth raises a whole parade of horribles in situations where the police cannot get warrants or wouldn't be allowed to go into a car. But a lot of this stuff is exigency. So you leave something dangerous in a wide open car that is out in the street, add in children running by, loaded gun, then you start to see, it starts to look more like exigent circumstances. And I think what we're saying is, rather than presuming that exigency exists simply because the car is mobile, then we need to look at the actual facts of each case and determine whether there are exigencies. And so when it starts to become, what about these facts, what about these facts, but this is clearly exigency and this is like this, it really is individual. And I think that's part of what Alexander stands for, which is we can't give one definition of exigency. But for car stops, only for situations where probable cause develops because of the officer viewing something, suddenly the Superior Court has read in this notion that because it arose suddenly and because the car is mobile, that is a per se exigency, when that's just not always the case.
Okay, I think we get it. Ms. Munz, any other questions? Let's hear from the Aplt. Very well argued.
Thank you.
May it please the Court, Mike Ehrlich for the Commonwealth. In Commonwealth versus Alexander, this Court overruled Gary and rejected the very broad all-purpose federal exception to the warrant requirement, according to which as long as the police had probable cause, even if they could have gotten a warrant long in advance, even if they were searching the trunk of a car or a glove box or private luggage within the car, everything was okay. Probable cause was the end of the inquiry for all searches of all kinds of vehicles. In Alexander, the Court simply had no opportunity to address the particular issue we have here, which is a situation where during a lawful traffic stop, an officer observes contraband in the vehicle in plain view. My learned colleague asked this Court to expand Alexander to establish a rule that evidence must be suppressed in these circumstances unless the prosecution proves at a suppression hearing that obtaining a warrant would not have been possible. I'd like to highlight 4 reasons why I think that would be a mistake. The first is I think that that is contrary to key aspects of the reasoning of Alexander itself, which incorporated the dissenting opinion in Commonwealth versus Gary. And that opinion emphasized the distinction between a societally reasonable expectation of privacy in all areas in the automobile shielded from public view and what Lehigh referred to as items left uncovered on the dashboard or seats that are no longer private in the same way. And I think this is an absolutely key distinction, and we're talking, when we talk about what is required for a lawful right of access, it is important to view that not simply in the abstract, but with reference to what the police are doing and what areas of a car are being invaded. And my second point, which is related to that, is that if we look at other jurisdictions that, like Pennsylvania, say Our citizens will have greater rights under their own state charters. We will not accept the federal all-purpose automobile exception. Over and over again, the weight of authority is they say, these cases are different. In these cases where the police see contraband in plain view in the car and they reach in and take it, that's fine. That is not a violation of our state constitution, even though the federal automobile exception goes way too far. Another factor that I think is important is that if you look at Alexander, what Alexander did was return the law of Pennsylvania to what it was prior to Gary. And if we look at that, the leading authority is McCree. It's a plurality opinion, but as both of us agree, you have to look at the facts accepted by a majority of the court, and they are binding. And in McCree, the court said that if you have plain view, you can go and access it and reach in, and that is not a violation of Article 1, Section 8.
Counsel, I apologize. Commonwealth.
Surely.
Plain view in and itself is per se exigent circumstance?
No, we're not saying that. The position that we've taken is that, and I think the court could take a narrower position if wished. Our position is it's a rule of thumb, that first the Commonwealth in all these cases has to establish that this was suddenly a rising probable cause that the police did not know in advance. And, of course, they have to show that the police saw the contraband from a lawful vantage point and knew that it was contraband. In that situation, we think generally if the police can go and readily access it, it normally does not require a warrant, but there are some exceptions. If you have a situation, as I've said in my brief, that involves the police smashing the car, damaging the car, breaking the windshield to get in, that gives us pause. That's a situation for that kind of additional violation of possessory rights, a warrant perhaps should be required. If you have a situation also where it's a mobile home or it's a car that is parked in the curtilage of a private residence, that's another situation where even if there's plain view, this court may well wish to, and it may well be a good idea to require a warrant. Our position is, as a rule of thumb, however, under the circumstances I've outlined, a warrant should not be required.
Can I follow up on that?
Surely.
Your response to Justice Dougherty, counsel, because I think your response is clear and it's consistent with your brief. It seems to get close to the Attorney General's proposal of a per se exigency insofar as 98 or 99% of these stops are going to essentially defeat Alexander, right? Because the overwhelming majority of these circumstances are going to be like this Saunders stop and not like the mobile home parked in the long-term parking at the airport or your curtilage case. So essentially, if we go down the avenue that you're proposing, wouldn't it essentially swallow the rule that we articulated in Alexander? Because essentially, it would be a per se exigency. And the companion question is, why isn't the better differentiation the differentiation between what we had here and the ticking time bomb scenario, which is a per se exigency?
Well, if you have the ticking time bomb scenario, that's going to be 0.00001% of cases. That never comes up. And in terms of swallowing the rule of Alexander, in the vast majority of car stops, you're having, prior to Alexander, you had situations that were not plain view. There's nothing that we are proposing that would allow the police ever, based on probable cause alone, to go into a trunk, to go into a glove box, to open a suitcase, to do all those things which are particularly troubling. And so I think that, yes, in most of these cases, our position is that plain view really should provide a right of access. But if there's ever a case where it should, that's narrower, it's this one, where you have a car in an area known for shootings, the door is open, through no fault of the police, it's through the fault of Mr. Saunders, who attempted to hide his gun. You have, his family living around the corner. We don't know when they'll be coming up. We have a situation where it's simply reaching through the open door inches, seconds. I think you would be hard-pressed to find any police officer confronted with that situation who's going in the field to be conducting some sort of nuanced analysis of, I wonder how many other police officers are available on call right now.
Well, wait a minute.
How many other magistrates?
Brief follow-up. Now you've varied the facts, because I've watched these I've watched the Ibbotson body cam and the Washington body cam a couple times. Saunders is removed from the car. He's handcuffed. He's put in the squad car. Washington's in the car. Ibbotson's at the car. So what? I mean, the gun's not going to shoot itself. What is the relationship between what happened in this case and the scenario you're talking about, where there's some crowd grabbing hold of the gun, or I'm not sure what exigency you're trying to paint.
What I'm trying to describe is this case itself. I don't think in this case any well-trained police officer really is going to be conducting some sort of sophisticated, nuanced analysis where they're trying to weigh how long would it take to get a warrant, how many other police officers are out on other calls, how many magistrates are available tonight.
That's true in every stop. I mean, you're retreading ground that we spent a lot of time in Alexander going over. I mean, that's the argument in every case. You know, things should be easier for law enforcement because they shouldn't have to think about this. Well, that's not what Article 1, Section 8 does. But I'm going to reiterate my concern that I discussed with your opposing counsel. What you are suggesting has never been the law in Pennsylvania, that somehow there is a different mode or test in a plain view case for what is otherwise allowed in an automobile search. The fourth prong of the plain view test has us look to a lawful right of access. That equates with what is necessary for an automobile search in Pennsylvania, which after Alexander is probable cause, which you otherwise have, and an exigency. So this notion that we should develop some different level of analysis for an object seen in plain view in an automobile other than what we have in usual automobile searches, that's just never been what the law has been in Pennsylvania.
But I think that's exactly the question before this court.
Maybe it is, but I'm just saying, you're arguing as though this is what the law has always been. That is just not true. In McCree is interesting because it was a plurality decision. They sort of dispensed with the fact that the object in the vehicle was in plain view or not. I mean, that case focused on what the quote-unquote limited automobile exception was in Pennsylvania for purposes of fulfilling the fourth requirement. I mean, it was long after the fact, and I wrote the decision in Brown, where in order to look for some potential majority holding in that case, we needed to focus on the narrowest thing that could be said. And it was in that case, in a plain view case, this is what the holding was. I mean, McCree essentially decided McCree. The analysis in that case had nothing to do with developing some newfangled view of the plain view exception in Pennsylvania.
Well, I guess there's two ways I respond. Specifically, I respectfully disagree, and I think that Your Honor's own holding in Brown really construed McCree as a specific ruling that had to do with plain view.
Now, that was the only point that could be drawn out of that case. We specifically said in Brown, it is clear that the court could not agree on the parameters of the limited automobile exception in Pennsylvania, which is what they were trying to do in order to determine what the lawful right of access was.
Whether or not that's the only point that could be drawn out of McCree, the fact remains that that was the holding of McCree as construed by Your Honor and the Superior Court ever since. And I think, however, that there's a broader point here, and that is that if you look at what my learned colleague is suggesting, that there's some sort of per se rule that you always need proof at the suppression hearing that the police could not possibly have gotten a warrant, well, that was rejected not only in McCree but in a whole series of cases construing the Pennsylvania Constitution by this court, in cases like Love, in cases like Baker and Rodriguez. That was never the law of Pennsylvania. The other point I'd like to make is something—
What was never the law of Pennsylvania?
That the only way that you can establish a proper warrantless search is if you prove that the police could not possibly have gotten a warrant had they guarded the car and gone through some sort of process to go and get a warrant while somebody's watching over the car.
Are you saying that even after we decided Alexander, that we are supposed to presume in a case like this, where the guy is out of the car, handcuffed, and in the back of the police vehicle, that his car remains mobile and that we don't have time to get a warrant for that car? Is that the proposition even after Alexander?
Not that the car remains mobile, but actually in this case, there was an actual finding of exigent circumstances by the trial court in which he said he reasonably believed that the officer's safety was in danger and there was a compelling need to recover the firearm while waiting the significant time it could have taken to get a warrant. So there actually was a finding here. And in terms generally of this analysis of what needs to be presented at the suppression hearing, I think we have to have a realistic view of what getting a warrant under these circumstances really involves. It's a three-part process. First, you have to go and have somebody, in addition to keeping an eye on the weapon, somebody keeping an eye on the defendant, you have to have somebody drafting the warrant affidavit. And that's something that most police officers on the street aren't an expert on. They often need to go and track down the detective to do that.
Commonwealth, the way I see this is Alexander put an end to Gary, kind of resurrected McCree. Before us today is an expansion or the creation of a new requirement, and that would be if we're arguing in a plain view. Since Alexander, if it's a plain view exception, we need probable cause and exigency. We're now conceding, or both of you appear to concede, that a fact-specific assessment has to be determined whether exigency exists. The question I have is, in this particular case, the officer indicated that he had fear. It was North Philly. I looked, it's the 2400 block of North Indiana Street, which is a very populated little street. If this fact scenario indicated that it was, say, maybe a joint or a nickel bag, is it your position that that would create a fact-specific assessment elevated to the level of exigency, unlike a firearm?
Yes. Now, I understand that the court may not agree there, but our position is, and this has been the position also in other states construing their own state constitutions that reject the federal automobile exceptions. Some of those cases are firearms cases. Some of those cases are drug cases.
But then you are asking for a per se finding that plain view equals exigency. See, I can easily distinguish a firearm on the 2400 block of North Indiana scares me. A nickel bag or a joint can't kill anybody. Not such a big thing for exigency. But you're telling me, or telling us, that it is, which, to me, what you're saying is we want a per se rule that plain view equals exigency, and we're not going to do that.
Okay. As I've indicated in my brief, our position is not a per se rule or position that it has to be suddenly rising after a traffic stop, and that there are other special circumstances that would elevate the privacy interest involved such that a warrant would be required.
What would be the special circumstance between a joint and a loaded firearm?
In either event, the police have no advance warning, and there's a question of what is practically required before the police simply reach through a window and take a nickel bag, rather than go through the process of guarding the car, having somebody go and draft a search warrant, then having the DA's office review it, which has to be done in Philadelphia, and then waiting for the first
the question really is about plain view. We're talking plain view. Leave out this concept of warrant. To me, it's like a red herring. We're talking an exception to the warrant requirement. We're looking at plain view. To get lawful access, we have to have a fact-specific assessment for exigency. That's what Alexander has created for Pennsylvania. The question I have is, what I'm hearing from you is plain view in and of itself, no matter what this contraband is sufficient to meet that fact assessment for the creation of exigency to substantiate the fourth prong of plain view. Does that make sense to you? That's what I hear you say.
It's our position that, yes, it ordinarily would, but I understand the court might not go that far. And I would also refer, Your Honor, to what former Chief Justice Saylor said in this concurring opinion in Perry, and that's that exigency isn't susceptible to a simple definition, because in viewing what kind of exigency is necessary, we have to look at the degree of the privacy interests in the space invaded. That's very high in the trunk and the glove box in many areas in the car. We're dealing with something else where you're just reaching through an open car door to take something on the seat.
That doesn't seem to me, counsel, to fully respect the court's decision in Alexander. I mean, we adopted the Gary dissent, and you seem to be arguing from a place that is essentially pre-Alexander. I don't understand why, after Alexander, cars are any different than houses. I mean, there's a protected privacy interest in a person's vehicle after Alexander, and so, and again, I return to the hypothetical that was posed earlier about somebody. About an officer seeing a gun through an open window in a house. The officer has to get a warrant. And it's different, than the officer seeing a bomb about to go off in a house or a bomb about to go off in a vehicle. I suppose your whole argument seems to rest on a distinction between cars and homes that is not there anymore. Would you like to respond to that?
Yes, I think it is there. I think that what Alexander did was return the law to pre-Gary. Gary was an aberration, and under Pennsylvania law prior to Gary, there was never any finding that houses and cars are the same. There is certainly an enhanced privacy interest in cars in Pennsylvania beyond what the federal government will recognize, or the U.S. Supreme Court will recognize under the Fourth Amendment. We agree with that, but a car is not a home, particularly these open areas of the car that anybody can see walking past on the street.
Well, that's what I was trying to get to, and you hail Alexander was a full search of a vehicle, wasn't it? It was
correct.
It was closed compartments, coverings. I mean, it was not a plain view search and seizure.
Correct.
So I can sort of understand why the court went the way it went in Alexander and said, there's no blanket automobile exception, but to consider the reasonableness of the warrantless search here under the plain view doctrine, don't we have to consider the fact that they didn't open up compartments, they didn't pull anything off, they literally didn't search for anything, they retrieved something in plain view that anybody could see that there was really no concealment, no effort to exert privacy with it?
I think that's exactly right. If I could...
Well, there was an effort. In fact, that's what caught Officer...
Failed effort. It was a failed effort.
Failed effort because Saunders
there was
made
an
a
effort
movement to push it under.
Yes.
So there was an effort.
Yeah, I mean, this is a case of poorly hidden equals in plain view. I mean, this is the margins of plain view, but that sort of is what it is. And I really do have to take exception to part of what you said about the expectation of privacy in automobiles in Pennsylvania. Your statement really ignores the major thrust of Alexander, which was dispelling the federal rationale that there was a much more limited expectation of privacy in motor vehicles. The Gary dissent went into great detail about
excellent
dissent. And the majority in Gary went to great lengths to describe the difference under Article 1, Section 8 and the federal Constitution and how that impacts an automobile and an automobile search. So, I mean, to say that what Alexander did was go back to Gary analysis just sort of ignores the thrust of the privacy interest that was recognized in Alexander.
Well, you will have to decide that. I would respectfully disagree. I think what Alexander did was to get rid of Gary as an aberration. The court went and agonized over doing that and considering the stare decisis considerations in doing that, and by a 4-3 vote decided to do that. And we completely accept that holding and understand it and have no problem with it. I think it would be very surprising if the court sub silento simply wiped out an entire line of cases interpreting the Pennsylvania Constitution prior to Gary.
Okay, let me go back to your answers to Justice Doherty's question, because to the extent you are going to persuade members of this court that this case had exigent circumstances or didn't need exigent circumstances, you were going on a track involving a loaded firearm, which has some appeal, whether or not we allow this under our construction under Alexander, I don't know. But you were on a track that had a little bit of appeal, maybe a lot of appeal. And then you answered the bag of marijuana question the same way. And so then you lost me, because I thought that your focus on plain view and exigency really depended on the fact that the officer had seen and knew there was a gun in there.
Well, I've tried to be consistent throughout. The position that we've taken in our brief is that our view of plain view is not limited to firearms, but if the court is unable to accept that, then
maybe you could just take about 10 steps back and say no to Justice Doherty's question.
Well, that would be inconsistent with my brief. I'm going to be consistent, but I certainly understand that if the court will not accept that, and if the court wishes to view everything that is not a firearm differently, I would still strongly urge you to affirm under the particular facts of this case. If I can just very quickly respond to one or two things that have been said. Counsel repeatedly states that the officer in this case expressed no concern for his safety. Ultimately, it's an objective inquiry, so it doesn't really matter. But the officer here said, I did ask him if he had a weapon on him, and he lied to me. He said he didn't, so I notified my partner for both our safety, and the trial court found that he had a safety concern.
This was after the individual was in the police car, though, wasn't it?
The actual removal. But the thing is, I think that there's been some position by the defense that there was never any safety concern throughout.
Yeah. But that's not with the lens we're using here. Or maybe, tell me if I'm wrong, that we're not looking at or are we at that apprehension moment? In other words, Saunders is removed immediately upon Officer Ibbotson seeing that gun and handcuffed and put in the squad car. And then Ibbotson takes the gun, he removes the clip in the chambered round, and it's sitting on the seat there.
Yes.
And that other squad car comes by and says, hey, do you need any help? And he's like, no, we're good. So I'm not sure I understand this whole argument about safety and exigency post-traffic stop.
I think that we made two arguments below, both at the suppression hearing and in our brief. One involved sort of Michigan versus Long, and we sort of acknowledged there that this would be an easier case if there had been a slight change, and rather than 2 minutes earlier, if they had simply taken out the gun before putting him in the car, I think it would be a straightforward case under Michigan versus Long. I think that this is honestly more difficult under Michigan versus Long. We argue that it simply didn't make an ultimate difference because defendant's privacy interest was the same, whether or not it's taken out in this very fast developing situation immediately before or immediately after.
You see, that's I think a problem. From my perspective at this point, I think that's a problem for you because when you talk about Michigan versus Long, it sounds like you want to try to make this a Terry case. But you would agree it's not a Terry case, right?
We made an alternative argument, one that it was permissible under Michigan versus Long, but the argument that we focused upon was really the plain view argument, and that's what I want to make the major thrust. The other point I just wanted to respond to is there's repeated discussion here about how the police are going about conducting lots of unjustified searches of cars, and there's a reference to a study of the Pennsylvania State Police of a survey saying that in only 53% of cases of car searches did they actually recover contraband. If you look at that study, you'll find that overwhelmingly over 70% of the cases they're talking about are consent searches. And once you take out the consent searches, then it goes up to 74%. It probably goes up to close to 100% if you talk about cases like this of actually observing contraband. So I don't think that the study indicates that there's some sort of terrible broad problem of police impermissibly searching cars. And to the extent that there is a problem, it seems to be a problem with consent searches and who they ask to consent, and perhaps in frustration over feeling that it's impractical to get a warrant, maybe really sort of asking for consent more than they should.
Do you want to wrap up, or have you?
I have.
All right.
Thank you.
Thank you, sir. Would you call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus Michael Thompson, representing Mr. Thompson, Mr. Michael Lloyd, representing Commonwealth of Pennsylvania.
All right. In this discretionary appeal, appellant was found in his vehicle, lethargic and slurring his speech, and he stumbled as he walked after exiting the car. A police officer determined that it was necessary to tow appellant's vehicle as the car was blocking several other vehicles. The officer performed an inventory search of the vehicle pursuant to written department policy and discovered a firearm. We are asked to decide whether the inventory search exception to the warrant requirement survives after our court's 2020 decision in Commonwealth versus Alexander.
May it please the court, my name is Michael Malloy. I represent Mr. Thompson in this appeal. If I may, I think in my reading of Thompson and reading of the Commonwealth opinion, or excuse me, brief, and the Superior Court's opinion, the debate seems to be about not the word search, but the predicate word. Inventory versus...
Sir, could you bring your microphone up? You're a little bit taller there. There we go. Thanks.
The issue seems to be, excuse me, not with the word search, but the predicate word of inventory or investigative. The position of the Commonwealth seems to be that, and of the Attorney General in their amicus brief, that all Alexander was saying is we're talking only about investigatory searches. That's not when I read Alexander. Alexander says we're talking about searches. And the predicate word of inventory or investigative, quite frankly, I don't think it applies. I think the real predicate word should be whether it's invasive or not. I think that's really what Alexander was saying, that as the court has already said in the last argument, there's no distinction now, I don't believe, after Alexander, between home and a car. The constitutional rights that were given to the homeowner were now given to the vehicle owner or the vehicle operator under Alexander. And in this particular case, this was a vehicle that was blocking some parking spaces in a commercial lot. That could have been, Mr. Thompson obviously seemed to be under the influence of something to be incoherent. Ambulances were first called. But there's no difference whether or not he was in that position where he had maybe had a fender bender and blocked parking spaces or blocked entrance to the commercial entity, and police responded to that particular call. And they decided, if the police decided, well, there's two cars here blocking, I'm going to call tow. Would they have the right at that point in time, if it's my car or someone else's car that collided in that parking lot, to go in and search? Because there's no distinction between that set of facts and Mr. Thompson's. And When I say the key word is invasive, the Commonwealth cites the case of Commonwealth versus NACE, N-A-C-E, a case decided by this court in 1991, which upheld, pre-Alexander, the search of the vehicle. And in that particular case, when the officer did an inventory search, he went through and found things belonging to the individual. He found a wallet. In the wallet, he opened it up and went through the contents of the wallet. In the wallet, he found an address book. He then went through the address book and found the victim's name. This court upheld that as part of the inventory search permissibility, because basically you can search anything. That's how invasive it could be. We're not looking for a firearm. We're just looking. And we go into trunks, and we go, and if you follow the logic behind NACE, that I think is a 1991 case, what you have in this day, if that logic were to stay good law, if an officer today goes in and finds a cell phone, well, if NACE says he could go through the address book, I could go through that contact book, or contact. I can go through, see if he ever made contact with other witnesses.
You're kind of going down that path of at what point in time should we, at some case, I'm not sure this is the case, draw the line on what is or is not a permissible inventory search? When does an inventory search cross the line into an investigative search? But I don't think that's not what we have here. We don't have any of these searches within a search fact pattern. This was a straight-up inventory search where contraband was immediately identifiable.
I agree with that.
So I guess the question, the real question in this case is, at least I think it is, what would a warrant have looked like?
Well, quite frankly, I don't know if they could have gotten a warrant. I mean, going back to Alexander, right? Alexander says the first default decision should be to go to a magistrate to determine if there was probable cause for a search warrant.
Right. And if you're doing an inventory search, you don't have probable cause. You're just doing an inventory search. So if you win, unless the owner of the vehicle who has been arrested or is maybe not even present consents, there can never be inventory searches in Pennsylvania.
Well, there may be multiple factors. I mean, somebody may say, you may have a witness at the scene who says, I saw him get out of the car, it looked like he had a gun, or I saw him how to get out of the car and do certain acts. That may lead to a magistrate to determine those particular set of facts may justify a warrant.
No, but we don't have that.
Right,
we don't have that. I'm trying to figure out what the natural implication of your argument is in this case, and I think what it is inventory searches are not permitted in Pennsylvania absent consent. It has nothing to do with the Fourth Amendment or the Pennsylvania Constitution, because you could never get a warrant on an inventory search. You don't have probable cause to believe that the car has contraband in it. You're doing the search for a completely different purpose, to make sure that you itemize the contents so later on when the vehicle is returned, you're not sued.
Well, the first part of that question, I agree. I agree that that there is no distinction. That's why I'm saying at the beginning, there's no distinction between an investigatory or an inventory search. There's no distinction. You need a search warrant to go in, period.
Well, there is a distinction in the sense that an investigatory search, you're searching for criminal conduct. And arguably, you could get probable cause to search for that. You can't get probable cause for an inventory search. You cannot get a warrant.
Well, I mean, if you do it, you're correct. If it's an inventory, if you have a search warrant and you do an investigatory search, or if you're doing a non-search warrant investigatory, that non-search warrant investigatory search is an inventory search. That's what I would argue.
Wasn't your point there that, following up on Justice Brobson's question, I took something you said a moment ago to suggest a scenario in which Thompson's arrested, they have an outstanding warrant, it turns out, they bring him in, the car is towed because it's got to be towed, but then in the course of working on Thompson, they develop probable cause to get a warrant to search that car, then they get in the car. What you're saying is, after Alexander, they don't just get to search the car on some inventory theory. Isn't that the point?
That's correct.
Okay.
I mean, if they might have found drugs on him, they might have found something on him when they patted him down, and then that would have led to holding the vehicle and going to get a search warrant.
Under that scenario, police have no reason to believe that there's contraband in the car at all. But they don't want to take the vehicle and then give the vehicle back, and the owner say, hey, I had a wad of bills under the console here. I had really expensive Dyson hair dryers in the back seat. They're all gone now. You guys owe me, and they file a suit. You're saying, in light of Alexander, sorry, inventory searches are are not allowed. You can't protect yourself at all, and we're just going to have to deal with those suits as they come.
I would respond in light of the argument of protecting of police officers from allegations of missing items is, quite frankly, a red herring. It's a red herring because the fact is there's no need to inventory. When the tow truck company comes, they don't inventory. They realize they're taking that vehicle. They never open it. They lock it. They take it locked. So then when the owner of the vehicle shows at the towing pound and they say, well, I had an iPhone in here. We never touched that car. We never went in the car. The reality is by going in the car, you're exposing yourself to liability. Because there's no reason to go in there.
Counsel, I'm going to just ask you to stop till the sirens go by.
They're on their way to an inventory search.
It sounds like it sometimes for my clients that way, but I'll wait, Judge. Your Honor, excuse me.
I think that's the end of them. Okay.
And that is the reality. By entering that vehicle, what's the need for going into that vehicle? I know they say it's so that we don't get blamed for items missing. But if you lock it, you can't get blamed. And if you take the scenario where they went into the vehicle, for example, and you're missing the iPhone, you're missing the diamond ring you bought that day, and you're going to go pick it up, and you say to the tow company, I had a diamond ring in here. I had an iPhone in here. They said, we never went in. Well, I'm going to sue the tow company because they had the vehicle, and they're going to, the first person they're going to bring in is the police officers because they went in. All the police officers are really doing is exposing themselves to liability. Because the point is, why are they going in? Why are they going in? What is the purpose of going in? If they lock it, they're 100% protected. Because even if you had the best inventory search ever, you still may miss items. And therefore, you're going to be blamed for it? No, the tow company is going to be blamed for it. And the reality is that there's no need to go in for that vehicle.
Counsel, share with us how Alexander is applicable to your case when Alexander did not involve an inventory search.
Well, my position is it involves searches. It involved the expansion, or no, not the expansion, but the application of Article 1, Section 8. That it didn't make a distinction. You're correct. It did not make a distinction. It made a distinction, however, of a search. I know it's easy to make the comparison to a home, but the point is to make a search. What Alexander did was took away the protection of the automobile exception as far as getting into a vehicle. And this court, in the prior argument, made that.
Repeat that again?
It took away the automobile exception. Alexander.
The federal Alexander.
The federal. I apologize.
I was going to say, all it did was create a new requirement of a fact-specific assessment of exigence.
Correct. I apologize. The federal automobile exception.
Okay.
And the prior argument from this court today was, what is the distinction between a house and a vehicle? And the question is, like I said at the beginning, it's not whether it's an inventory or investigatory. It's whether it's invasive, whether it's violating that right against an unlawful entry and search to the home or the vehicle. I think the court in Alexander didn't feel the need to itemize home, Alexander, trailer park, whatever it may be.
Yeah, counsel, can I just follow up on that? Because there are circumstances under which a police officer can enter a house without a search warrant. And it falls within this same context of administrative searches or community caretaking functions. And so that's the difference between Alexander and this case. I mean, this case involves an administrative or community caretaking function versus investigation. And that distinction exists in homes also. I mean, I get it. You're a little bit skeptical about the inventory search in general and the exception for it, but that doesn't mean that Alexander encompassed that entire field.
All due respect, I don't believe that police officers could go into a home and begin to inventory a home.
No, but officers can enter into a home without a search warrant under certain circumstances for community caretaking purposes. And if they have to, in the context of entering to, save a life or search for a bomb or something of that nature, they have to, go through people's belongings and things like that. I mean, it happens. I mean, the gas leak cases where, government allows entrance into homes to determine on a regular basis whether or not the gas lines are working, et cetera, et cetera. I mean, there's a whole area of law that encompasses these administrative type searches, and that's how we have always looked at inventory searches, as opposed to an investigative search, which is what we had at issue in Alexander.
That is how we always looked at it. But in all the fact scenarios, respectfully, that you gave, they would be exigent circumstances that would also apply to a vehicle. In other words, if it's a gas leak or something to that effect that needs, whether it's the inspection people to come in or somebody else to come in to secure whatever is going on in the house, smoke, fire department would have to come in, the police would probably assist. That's an exigent circumstance. If they're in there doing an administrative procedure, not a police procedure, and they observe things, and then we're going to get into a plain view argument we just had, but that's different. They're not coming in. They're simply not coming in because the people left the house, and somehow or another the police feel, well, we were told to hold it here. Maybe we were told to hold it here while we go see if we can get a warrant for the house. So we stay outside and we hold the house. But instead, we can go in the house just to make sure, in case when somebody comes, that we're not accused of taking something. They are administrative procedures, whether it's the gas line, the water line, the fire department. They are not law enforcement in going into the house for searching and going through individual items in the house. That's how offensively personal the search can be. It's going to go through my briefcase. It's going to go through my computer if it needs to. For what purpose? The purpose would be, if you're going in for the gas line, well, what purpose are you going through that items? You should be checking the gas line. You should be checking whatever else brought me to the house. Missing person? Absolutely. But what are you going through my personal belongings for? And that's what that's you could not have that situation in a house. And under Alexander, you cannot have that in a car or a vehicle, I should say. We always talk about cars, but obviously we know there's more than that. There's trucks, all vehicles. Those two items are equal. And they're equal as far as exigent circumstances that may be created. You may see a bomb in a car. You may see something of a leaking gas that may justify exigent circumstances going in. But you simply just can't go in because you're going to tow the car. And in the case of the house, you're not going to be responsible other than what you did administratively in the house. If you kind of screwed up relining the gas line, yeah, you're going to be liable. But other than that, nobody's going to say they went into my jewelry box and took stuff out, or some of my personal belongings are gone, because they didn't do a full inventory.
All right, anything else?
No, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Kelly Weir representing the Commonwealth. This case before you really presents a very narrow issue. The question here is only whether Alexander abolished the inventory search exception. It's not whether the inventory search exception could or should be limited in some way. And the Superior...
What's the difference? I mean, what's the difference between them? Doesn't Alexander burst the bubble of the inventory search in Pennsylvania?
I don't think it does, because Alexander, just like Gary was before it, talked exclusively about probable cause searches. So whether or not it used the word investigatory, Alexander and Gary are both assuming the presence of probable cause. It's right there in the very first sentence of Gary. It specifically says in that first sentence that they're only talking about warrantless car searches that are, quote, supported by probable cause. So then when this court picks up Alexander 6 years later, again, right in that first sentence, they make it clear that they're addressing a very narrow issue. This court said it's just deciding whether to overrule or limit Gary. So it's confining itself to that same universe that Gary decided, that universe of a probable cause search. And at its essence, an inventory search is just so diametrically different from an investigatory search. It's a caretaking search. It's right there in the test for an inventory search.
Counsel, let me ask you a question. What if the individual whose car is seized doesn't want an inventory search, doesn't care about the caretaking function? Do they have a right to opt out? We've already established that one's based upon probable cause to search, Alexander, correct?
Yes.
The other one's not. The other one's an inventory search for a community caretaking function. There's a little bit of a tension there with Article 1, Section 8, right?
I think certainly if that would be a limit that the court could consider in the future, whether individuals can opt out of inventory searches. I would also point out, though, that protecting the owner's belongings for his benefit is just one of the interests that the inventory search exception was created for. It's also obviously to protect the police from false claims of loss.
But what if we create an exception to the inventory search where the owner opts out and signs a waiver to not sue the police if anything's missing?
I think in a future case that briefs that issue, that presents that situation, that could be something to consider. That's obviously not what we have before us today. He didn't opt out.
Well, it's much more common in Philadelphia for cars to be towed by tow truck operators. Do they inventory? Do they do an inventory? I don't think they do they?
My assumption
and so is there a
would be that
spate
they
of lawsuits against all these towing companies in Pennsylvania? Do we see a spate of lawsuits against them for stolen property?
I couldn't speak to the frequency of the lawsuits, but I can say that the tow company has a much more limited interest in when they're towing the car than the police do.
Well, if it's not investigatory in either case, then how is it different?
I think, well, number one, the police are interested in protecting against false suits, just like a tow company would. But they're not just interested in that for their own purposes. Society has an interest in the police not spending their resources defending against these false lawsuits. That's what Justice Powell said in Opperman. But there's other concerns also at play for the police. They're also concerned with, as caretakers for society, in protecting the owner's belongings. They're also concerned with avoiding danger that may occur. That's a function that the police officer is supposed to carry out. It's not a function that we expect from our tow companies.
The danger is addressed by the exigency doctrine. If there's a bomb in the car, or a smell of chemicals about to go up or something like that, that's all taken care of. I mean, that's not in contest here. It's this apparently mythical Opperman construct, which is in deep tension with our decision in Alexander. And I guess I'd ask you why we should respect Opperman post Alexander on this theory that officers have to do this inventory with a car that they don't do when they search a home, for example.
I'll make a couple of points. I'll try to get off track. So first, as to the exigency, I don't think that is covered inherently by, when the police officers are seeing a car, for instance, if a bomb is in the trunk, they're not going to know that it's there. So they may be sending that off with a tow company with something inside the car that's dangerous. There's also the element that something that's innocuous could become hazardous to someone taking the car that's not aware of it. I think that was one of the concerns that Justice Powell indicated. These hazards are rare, but the consequences of them can be great when they're there. And it's not always immediately apparent just by looking at a car whether this one's a hazard or this one's a hazard.
Well, there's no we agree there's no probable cause here, right?
Yes.
So suppose I said to you, would you like me to go through your things to make sure I don't steal anything, or to make sure there's nothing in there that's going to blow up on me? Would you mind?
I think if you were somehow taking custody of me in that scenario and, I don't know, moving me like in the context of a booking search, yes, I think you should. And I think that right there is the difference here between a home and a car. If you use the example that the defense offered in their brief, he said, if you arrest somebody in their home, well, you're not going to inventory the home. Of course not. You're not moving the home anywhere. You're not taking responsibility for it. You're going to leave that home right where it is, completely intact. But you are moving the person. You're taking responsibility for that person and taking them into custody.
Well, couldn't the homeowner later say, those police officers stole all kinds of stuff from my home? In fact, there's all kinds of little knickknacks they might be able to, I'm not saying they do, I'm saying under your construct, right? What's the difference? Couldn't the defendant there later say, hey, they stole all kinds of stuff from my house, it wasn't inventoried? Or how do the police know there's not something in that home that isn't going to be combustible and blow up? I just don't see the difference with a car there.
I think the difference is that when you're affirmatively moving something, you're affirmatively essentially taking it into your possession, or you're responsible for it being in a different location, you're ensuring in a way that it's going to be safe, that it's not going to pose a danger to the public. I don't think that a house is posing any added danger to the public because the police walked in the door. If it was a danger before they walked in, sure, it's going to be a danger after. But it's not going to be a danger because the police had it towed. And that is a scenario that, although unlikely, is possible in the context of an inventory search of a car.
Well, I guess just one last thing on that. I mean, I think it ought to alarm residents of this great city to think that anytime they park a car here, if it's towed, that car is fair game. Everything in that car could be inventoried. Isn't that the logical extension of your point?
I think that if the police are towing the car because it poses some kind of public safety risk or some kind of huge traffic obstruction, I don't think every single time a car is towed would you conduct an inventory search. I think the point of it, and this case is a great example, it's not just that this car wasn't where it was supposed to be, it's that it was posing an obstruction. It had to be towed for that reason. So yes, under that circumstances where the police are the ones doing it, the police are the ones moving it, I think you are entitled to conduct an inventory search under those circumstances.
Why? What do those circumstances add to the notion that there's something potentially dangerous in that vehicle versus a car just parked on the street?
I think it adds the involvement of the police versus if it's just a private tow company that's conducting the search. Because it's not just a danger element, it's the interests of the police, it's the interests of protecting the owner's belongings.
What is the interest of the police? I'm really confused about that.
I think the interests of the police are most specifically about protecting themselves from false claims of loss.
But
false claims of theft.
there's no, is there, I'll put it this way, what evidence is there of some raft of claims against the police for stolen property? I mean, there's not even a scintilla of evidence of that against these private operators. So much the more would we doubt that there's some looming threat of a mountain of claims against the police for such.
Well, I would say, I mean, first, I don't know if tow companies regularly face lawsuits. It's entirely possible that they may.
They limit their liability.
Yes.
And they're probably bailees. And I don't know how the police are any different in that circumstance. I mean, this rash of lawsuits, that's what I said. I just don't understand where that notion comes from.
You know, I think it's important to remember, though, that really these concerns about should there be an inventory search, at the end of the day, are a different question.
From a public policy perspective, wouldn't we be better off having the police have no involvement with towing the car? In other words, if there's a car parked illegally, call a private tow company and have them tow it and take responsibility for it. This way, the police don't have to conduct an inventory search. You don't have to worry about an illegal search and seizure. You have basically a private company basically doing the job that you're insisting that the police officers should do, and in order to insulate themselves from liability, to conduct an inventory search. Wouldn't we be better off just having a private company do it as opposed to the police?
Well, I mean, I'll say more narrowly, I don't think I'm saying inventory searches should exist forevermore in exactly the state that they are. What I'm saying is that Alexander didn't abolish them. And what I'm also saying is that at the end of the day, an inventory search is very harmonious with many of these ideas about privacy, about protecting those interests that Alexander was talking about. It's baked right into the standard that these searches have to be reasonable.
Well, it's tremendously convenient. I don't dispute that it's tremendously convenient for law enforcement to have the benefit of inventory searches, but I'm still not hearing from you any basis for suspecting that post-Alexander they should be deemed constitutional in this Commonwealth.
I think they should be deemed constitutional because Alexander had nothing to do with caretaking searches. I mean, when you look even just at the reasoning of Alexander, a lot of Alexander and of the Chief Justice's dissent in Gary, a lot of those opinions talks about the ease today of getting search warrants, that it's so much easier today for the police to just go out and get a warrant. We should encourage that whenever it's possible to do that. Well, yes, in the context of an investigatory search, that's obviously relevant. But you can never get a search warrant to conduct an inventory search. So if we're going to apply Alexander to inventory searches, well, that's the first chunk of the opinion that you essentially have to carve out. And it's not the only part of the opinion, unfortunately.
But this is just a way of defeating Alexander. I mean, in reality, it seems divorced from reality to suggest that there's no investigatory motive in these inventory searches to claim that these are to protect officers from allegations of theft. How can that claim be made with a straight face post-Alexander?
I think that if we're going to require that a search have no possible, even conceivable slim chance of an investigatory motive, we're essentially asking police officers to turn off their brains. I mean, anytime they go into a car, a house, any situation, there's a possibility that they might find some evidence of crime. And I think this court has consistently recognized that caretaking searches are important, that caretaking searches are reasonable.
Well,
and because of that, they have a different value.
I don't want to get too down. I'm not going to get too far down the idea of motive versus non-motive. I think police officers who do inventory searches probably have very good motives, and maybe there are some that don't. But I'm not going to assume ill intent. I agree with you that Alexander is somewhat different and of limited application, because Alexander really was like, you get a warrant. So really all this comes down to is, under Pennsylvania's Constitution, and I guess under the federal Constitution, is an inventory search reasonable? Is an inventory search, period, because you would not get a warrant to do an inventory search. Is an inventory search in and of itself an unreasonable search and seizure? Is the car here, obviously, the car has some privacy interest that is protected under the Pennsylvania Constitution. I misstated. The person has a privacy interest in their vehicle because it protects the person, not the property. That is deserving of some constitutional protection. So doesn't it just come down to the question of the reasonableness of conducting an inventory search under these circumstances?
Yes, and I think an inventory search is entirely reasonable. It's a caretaking search, and frankly, reasonableness is in the standard.
So Commonwealth, the question before this court is whether the trial court and the Superior Court erred in determining the inventory search of an automobile as an exception to Pennsylvania Supreme Court decision in Alexander, requiring search warrant before conducting a search of a person's vehicle, or requiring the production and proof of exigent circumstances for a warrantless search. So the way I view this issue is, post-Alexander, in any types of searches, aka in this case, an inventory search, does that remain an exception to the warrant requirement as is under the caretaking exception? Or, post-Alexander, do we now, when we're looking at warrantless exceptions, have to have a fact-specific basis for exigency to justify the inventory of a car? What is your position? That's how the question's framed in my mind, and I haven't gotten a real answer.
I think post-Alexander, we're in the exact same position that we were before Gary, that an inventory search is an exception to the warrant requirement, that it doesn't require that kind of fact-intensive analysis.
And you're basing that, I'm sorry, you're basing that on the fact that Alexander involved a warrant, a probable cause, and not an inventory search?
Yes.
Got it. And you're maintaining, counsel, to follow up on that question, that the officer takes off his investigatory hat and he puts on his or her community caretaker hat. So in the community caretaker space, if there's a baby, crying in the back seat, or a person, is falling out in the back seat, there's your caretaker situation. But here, you're talking about calling in the car to be removed, and then under the premise of that removal, rooting through it and looking for what's in the car. Aren't those different kinds of scenarios? And why not just get a warrant for that car? And if you don't have probable cause, then try to develop it through interrogation of the defendant or some other investigation. Why is that so difficult?
Because you could never get a search warrant to conduct an inventory search. It's right in the standard that it can't be for the sole purpose of investigation. So if you go to get a search warrant, you have to show there's a fair probability evidence of a crime is going to be found in this car. Well, if that's why you're going into this car, you're not conducting an inventory search anymore. You're
right,
conducting...
so it's circular, right? Because we all know that a hunch is not enough. So if I just have a hunch, but I think if I can tow the car and an inventory search will, by my hunch, turn something up, I can get around the problem. Why should we allow that? What's the caretaking function there?
I think it's important to remember that inventory searches are standardized. There's not a huge amount of discretion for officers to say in these situations, well, maybe I have probable cause, maybe it's just a hunch, I'll just do an inventory. They have to be following a standard police procedure before they can do this. The police procedure has to be reasonable, and they have to have the lawful authority to tow the car. And so I think that's part of why we don't have a search warrant equivalent for inventory searches, because right there in the test is that standardization. You don't need a neutral magistrate to go in each and every case and see, is the officer's hunch enough? They're not operating on a hunch. They're just following a standard procedure and essentially checking the boxes as they go. Now, if the policy is too broad, if the policy is invading too much into an individual's privacy rights, which, could certainly happen in cases, then there's an easy means to challenge that. The standard says right there, the police procedure has to be reasonable. So somebody can go to court and say this policy the police have adopted is not reasonable. Say, for instance, the police department says, oh, well, you grab somebody's phone and then you turn it on and you inventory every single little detail that's in the phone. I think that would very clearly be an unreasonable inventory search. You don't need to do that. That doesn't serve any of the interests that are articulated in these inventory search cases. But to actually just seize the phone and protect it until the defendant's able to come claim it, I think that is reasonable under the circumstances.
Any other questions? Do you want to wrap up?
No, we just ask that this court affirm the Superior Court.
All right. Thank you, counsel.
Thank you.
Everyone, we're going to take a lunch break, and we will resume at 1 o'clock.
Back in session, please be seated.
Good afternoon, everyone. Would you call the case, Mr. Minner?
Crozer, LLC, versus Appeal of Chester Upland School District, representing the school district, Mr. Van Blunt, representing Crozer, Mr. Robert Bott.
In this appeal, a senior judge presided over tax assessment appeals in Delaware County Common Pleas Court after he had been appointed to a tax assessment appeals board in another county and had received remuneration for that appointment. The property owners appealed their tax assessments to the Commonwealth Court, which held that the jurist's conduct violated Article 5, Section 17A of the Pennsylvania Constitution, which precludes a judicial officer from holding another position of profit in government. The court further held that this violation resulted in the automatic forfeiture of the senior judge's judicial office and constituted a structural error which rendered the orders entered by the senior judge in the tax assessment appeals void ab initio. In these issues of first impression, we granted allowance of appeal to examine whether the Commonwealth Court was the appropriate entity to make this determination and whether the nullification of the orders entered in the civil tax assessment appeals was the appropriate remedy. Please proceed.
May it please the Court. Chief Justice Todd, members of the Supreme Court of Pennsylvania, Attorney Beyer. My name is Pamela Van Blunk, and I represent Chester Upland School District. The Commonwealth Court misconstrued the Pennsylvania Constitution when it created a bright-line rule that a judge automatically forfeits his judicial office upon a finding that he violated Article 5, Section 17. The Commonwealth Court's interpretation of our Constitution has great implication in three ways. It exposes litigants to the uncertainty of final orders. It created a new remedy for disappointed litigants. And finally, it usurps this court's and the Court of Judicial Discipline's exclusive authority to determine when a judicial officer is no longer vested with judicial authority.
But this really isn't a disciplinary matter, is it?
It involves judicial misconduct, Chief Justice Todd. And I will surmise and get into that Article 5, Section 17 is prohibited activities. Section 18 of Article 5 delineates how this court and the Court of Judicial Discipline and the Judicial Board reviews or reprimands or sanctions a judge.
Is there any other circumstance where lower courts are disempowered from adjudicating constitutional claims?
I'm not sure if I understand.
All right. Well, suppose this wasn't Article 5, Section 17, but it was instead Article 1, Section 8, which we heard a lot of arguments about this morning. Any reason why the Commonwealth Court couldn't adjudicate a claim under Article 1, Section 8?
I think the Commonwealth can always adjudicate whether or not there's partiality, whether or not there's bias, but if I could step back just a moment, Your Honor. Our Constitution does specifically delineate which offices are incompatible offices. That's a separate section. Section 17, that's Article 6, Section 2. Article 5, and that specifically says incompatible offices. What that provision states is that a federal office and a state office are incompatible offices. That section of our Constitution also empowers the General Assembly to, by statute, declare other offices, such as state offices and municipal offices, which is what we have here under these circumstances, as incompatible offices.
That's not, I'm sorry to interrupt, but that's not, my point is that it seems like the result of your argument would be that while even a magisterial district judge somewhere in Pennsylvania has the authority and indeed must resolve a constitutional claim when it's made at his or her level, you're saying for this particular section that nobody can adjudicate it except the Supreme Court and the CJD. And is there any other provision of our Constitution, or is this the only one?
So what I'm saying, Your Honor, is that the Commonwealth Court is not empowered to say that a judicial officer no longer is vested in his judicial office. There are two scenarios. Section 18 specifically says when a judicial officer automatically forfeits his office. Those two scenarios are upon conviction of misbehavior in office by court, disbarment, or removal under Section 18. The other scenario that a judge automatically forfeits his judicial office is the filing of paperwork to be on a ballot for public office other than a judicial office. Those are the only two scenarios that our Constitution expressly states when a judicial officer automatically forfeits his or her judicial office. What I'm saying is that the allegations of a constitutional violation by Judge Braxton does not amount to bias, partiality, or ill will by Judge Braxton. Instead, Prospect is asserting that there's a structural error. In order to get to that structural error, you have to remove Judge Braxton from his office, of his judicial authority to enter into final orders. How the Commonwealth Court got there was by saying that these two officers are incompatible offices. Now, and I will take Justice Weck's example a little bit further, a question, if I can. Section 17, there are several prohibited activities, right? There are also, judges can't take bribes, for example. Judges cannot sexually or racially discriminate against litigants. And they can't get a second job. Those are all prohibited activities under Section 17.
Does it make any difference that Judge Braxton was a senior judge?
In my mind, it does, and here's why. He was a conflict judge. The facts show that he was wrapping up his cases. The facts demonstrate that he was also assigned to judicial cases in Bucks County, and he was also assigned to conflict cases in Carbon County, I believe it was. Here, when he was appointed, and there is no facts showing exactly when he actually started serving, so that's another whole ball of wax. What does the term service mean? But I'm going off on a tangent here, I apologize. He believed that he was authorized to complete his conflict cases. All the trials
he disclosed, right, that he had this other position.
If you ask Chester Upland School District, he disclosed he disclosed that he was appointed.
Well, wait a minute.
He did not disclose that he was receiving payment.
Wait, can we stop there for a moment?
Yes, sir.
He disclosed. One might, as apparently the lower court did, take a different view of this disclosure, because on June 24, the judge said, "As soon as I leave here, I'm going to do that other post, and that's why I can't linger here. I'm going, et cetera, et cetera. I'm going to be sitting in Philadelphia." So that's talking about the future. The clear implication being that I'm here now. So actually, wouldn't you agree that the disclosure actually cuts in the other direction so as to throw Prospect off the trail to believe that he was still with the courts, so to speak, rather than sworn in and getting paid by the Board of Board of Taxes or whatever it's called in Philadelphia?
Sure, Your Honor. I believe that brings up a very good point with this whole procedural process, is that I don't presume that a judge is not being dishonest. I presume that the judge it should be afforded a presumption that his actions and his will, if you will, are to the good of the people, or to the good of the bench, right, for the security of the bench. There are no facts where he, in other words, he did testify at the remand hearing. There are no facts evident that he had any ill will whatsoever. Prospect does not allege that. There was, what he did say was that, yes, he was going to serve. What did not come out until the remand hearing was that he had already been paid. When he actually began serving, we don't have a concrete date. So it goes back to that funny word, if you will, what's the definition of service? But that just goes to the point of the problem with this, the way this procedure occurred.
I think there's a difference between deciding, assuming the court has the jurisdiction. I think the Commonwealth Court could have the jurisdiction to decide whether there was a Section 17 violation. The question is, if they do decide that there's a Section 17A violation, can the court do what it did here, which is say he forfeited his office? And that's what I think is really the nub of this is there anything in our Constitution in Article 5 that provides for the forfeiture of office for a 17A violation other than Section 18 and going through the due process that a judge is entitled to have through the judicial conduct of the Court of Judicial Discipline and appeal to this court?
I agree with Your Honor. That
it was a question. I wasn't. The question is this.
Okay, I'm going to agree.
I know it was a long one, but it still was a question.
I agree with your first part that is the nub. In other words, it's the remedy for a 17
so
violation.
Is there another process other than Section 18, another process that ensures the judge's due process for the removal of a jurist for a violation of Section 17A? Even assuming the Commonwealth Court could say he violated Section 17A.
Of course, I understand, Your Honor. No, there isn't. There's only so. Actually, let me step back just a little bit. There is when bias, partiality, or ill will are demonstrated. Commonwealth Court can always void orders under that scenario.
But that's not forfeiting judicial office. That's conflict. That's recusal. That's code of judicial conduct type of stuff. In the terms of disqualification on incompatibility, that he had some partial bias or ill will. There's nothing like that here. This is, at least that's not what's being alleged, has been alleged at all. This is purely he violated Section 17A. The Commonwealth Court says, we agree with you. He violated Section 17A. The question that I feel is before us is, okay, then what could the Commonwealth Court do what it did, which says he automatically forfeited his office, when under Article 15, Article 5, Section 18, that only can happen, or at least it says it happens there, after a Court of Judicial Discipline proceeding?
You're correct, Your Honor. There is no other mechanism for forfeiture, especially automatic forfeiture.
For a 17A violation.
Judicial office. Section 17 only lists prohibited activities. And if I will submit, under the Commonwealth Court's decision, Judge Braxton forfeited his office on June 16, 2019. What about his other orders? What happens to the order in Carbon County? The Commonwealth Court's decision and procedure and bright line rule does not account for that. Is the voiding of orders only rewarded to sophisticated litigants who knew to plead that?
But counsel, they were the only litigants who appealed. I mean, I think you have a problem maybe with the language that the Commonwealth Court used here, but I just don't. Who else would decide this issue on appeal vis-a-vis this particular case? The unhappy litigants went to the Commonwealth Court and said, this judge violated the Pennsylvania Constitution. We want relief. I mean, this judge didn't lose his pension, did he? I mean, well, that's sort of, where are his due process rights implicated at all? The entire purpose of this appeal was to give relief to the people who appealed the decision.
Yeah, he wasn't forfeiting his judicial office as a whole. The orders were void.
Correct, Your Honor.
In this case?
In this case,
You're correct, yes.
And so if they would have said, for purposes of this appeal, this jurist couldn't decide the case because he'd taken another job, therefore his order is void. Didn't use the word forfeiture, didn't do anything, just purely and simply decided this appeal. Would you still be here?
I would, Your Honor.
And why?
Because the Commonwealth Court, well, it depends on what the reasoning is for void.
Because he took a job that was incompatible with hearing that case.
And I'm going to go back to incompatible then, based upon what you just said, Justice Donahue. So nowhere in our Constitution does it say it's constitutionally incompatible for these two offices. It does say that they are prohibited activities. And I will go back to another example, the bribery example, or racial discrimination. A judge violates Section 17, violates our Pennsylvania Constitution, Section 17, if they take a bribe. I'm just being devil's advocate here. Suppose the trial judge takes a bribe in a divorce case, an equitable distribution case. The facts don't come to light until 5 years later. Under the Commonwealth Court's ruling, that judge forfeited his or her office at the time the bribe was taken. Does that mean all of the judge's orders for 5 years in criminal cases?
There was no timely appeal there, was there? These people made a timely appeal.
But if new facts come to light, can't you always bring that up if there was bias for a judge? I mean...
But that's not the case we have here. Are you saying that there can be no remedy on an appeal from an individual case based upon a violation of Article 1, Section whatever this is, 17?
No, Your Honor.
Article
that's not
5,
what I'm
17.
saying. No, Your Honor, that's not what I'm saying. What I'm saying is that the losing litigant has to show partiality or ill will or bias on the part of the judge.
That's a totally different species of claim, and so it's not this case. The question, I take it, is how do you square your position with the fact that we have a remedies clause? I mean, if there's a violation here, presumably there must be a remedy, and to simply say complain to the JCB is not a remedy for this litigant. So I don't see how your position squares with the remedies presumption.
Just because there was a violation of Section 17 does not mean that it affected this case, other than that the litigant lost. Just because there's a violation of Section 17 does not mean that it affects this case. That's why I keep going back to the partiality, the bias, in other words, that always comes to play.
You're saying Section 17A does not create a right of any individual litigant. It's a restriction on a judge. And, a litigant does not have a right to – you're basically raising a standing argument. A litigant does not have a right unless the judge has been removed. Then, of course, a litigant can't have a case in front of a judge that's forfeited office.
I think a litigant always has a right to appeal. It's what's the remedy, right?
Well, you're saying there is none. You're saying there's no remedy.
I'm saying that it doesn't affect the case.
Well, then you're saying there's no remedy.
What I'm saying is that there's no – because the Commonwealth Court found structural error. But before they get to structural error, they have to take away Judge Braxton's judicial authority in order to get to structural error, which means there's no harmless error analysis. I'm saying there is a remedy, but we have to go through that harmless error analysis.
But are you saying there's a right? I guess that's my question, is what is the right? We're talking about remedy. They have a remedy. Are you conceding that Section 17A, which is a prohibited activities of judges, not incompatible office, prohibited activities, creates a right for litigants, such that if there's a violation of 17A, a litigant is entitled to a remedy?
I haven't seen one.
Or is it a general right of the public that 17A creates?
think it's more of a general right of the public in that this court, on the Court of Judicial Discipline, the whole interest as a whole, and this is when our Constitution was changed and Section 18 was added, was obviously to protect the integrity of the courts in the eyes of the public, right? So, I mean, we all know why these rules are prohibited activities, so there's no appearance of bias, and so
Suppose you owned a piece of land and you sued somebody for damaging your land. And your case went forward in front of a judge, and the judge says during the charge conference or earlier motion limiting conference, by the way, I'm going to be taking a job with a law firm, so I got to get this done because I'm going to be going to Philadelphia and taking a job with a law firm. And then you find out, actually, he had already been drawing salary from this law firm and practicing law. Would you not have a right to appeal that judge's decision in your case?
I think the litigant would, but I still go back to harm. And in other words, where's the bias? Where's the partiality? I'm not saying that the facts are on my side. They're obviously not. The facts, it doesn't sound good. It doesn't feel good. But what I'm saying is that there are, the only thing I could do is equate it to bribery, because that's a horrible thing, right? That's even worse. I don't think Judge Braxton meant to do anything horrible here. I truly believe that he...
Well, we don't need to talk about whether he's evil or a brilliant, wonderful... It has nothing to do with that.
Yeah.
It's not a conduct proceeding. I guess you're saying that to show bias or partiality is somehow worse than a situation where the judge had no entitlement to be the judge to begin with.
Yes. And he did have, in other words, the Commonwealth Court actually took away his judicial authority. That's what the Commonwealth Court did. That's what they said. Judge Braxton, you did not have authority, judicial authority, to enter into these orders when you signed them.
Counsel, why would you not think Section 17 is self-executing?
Because no, it doesn't expressly say that. Why would Section 18 provide for automatic forfeiture if everything on 17, if every violation of every prohibited activity under Section 17 equates to an automatic forfeiture? And that goes back to my, bribery example, if you will. Section 18 expressly provides for when a judicial officer automatically forfeits his or her judicial office.
Counsel, could you go back to a question I asked a little while ago that I don't believe you answered? In your preparation of this case, did you conclude that his senior judge status was no different than full-time judge status, or that it was irrelevant?
I don't think it's irrelevant. It's certainly what we argued before the Commonwealth Court. I've done a little more research since then. I do think it's different, and there's two reasons why. I don't know if it makes a difference. Your honors will tell me if it makes a difference. But the first is the constitutional, I apologize, I don't have it in front of me. I don't want to flip papers. The Constitution says a judge shall devote
full efforts,
Right.
full-time or full efforts?
Right. And I can understand that from a judicial perspective and a judicial management perspective.
That kind of sounds a lot like a commission judge, not a senior judge.
It does, Your Honor. And again, Judge Braxton in this case was literally wrapping up his cases. We had gone through 28 days of trial, 24 days of trial. There are 4 days of trial that occurred after Judge Braxton alleged or purported, under the Commonwealth Court's decision, forfeited his office. What happens to those 4 days of testimony and evidence taken? That's just one practical aspect of it. But
well, I'm asking not so much about the practical aspect, but about the application. Is this the correct application? Did the Commonwealth take the correct remedial action, given that he was not a full-time judge?
I believe the Commonwealth Court understood and held that that it didn't matter that he was part-time or full-time.
Correct. But I'm asking you.
I think it matters. I think he, back and the rules have changed in the few years. when Judge Braxton was working, he only got paid for those days, and I don't know if it matters, but he only got paid for those days where he was on the bench on the record. He didn't get paid for reviewing our very voluminous findings of fact, proposed findings of fact, conclusions of law, and he didn't get paid for making a decision. He only got paid, again, I don't know if it matters, but when you look at the time that we finished the trials in this matter, and then we submitted our briefs, we took a few months. I believe he worked 6 days until his date of retirement.
Well,
you're retired.
It seems you're, pardon me, I'm sorry. It seems like you're arguing here a matter of degree. And the Constitution, Section 17, speaks to an office, quote, hold an office or position of profit in the government of the United States, the Commonwealth, or any, et cetera. And I think it's been well settled that that includes drawing pay from the Commonwealth. So you have this statement by the judge in June of 2019 making it plain to people that he's going to be doing this. And that then all the way until March of 2020, as I understand it, there's no disclosure that, in fact, he's been taking pay. Nothing illegal. I'm not suggesting that. But to suggest that there's a degree issue here because you're senior, you're not active, or because you're only being paid for X number of days versus Y number of days, why is that a difference of constitutional consequence?
And before you answer, could I just add on to that question? If you would focus on that Section 17A language that says judges shall devote their full time to their judicial duties. I mean, maybe that means if you're handling a case, you devote your full time to that case, but maybe it doesn't. Maybe it means something else that would disqualify a senior judge from the application of that provision.
Well, but I added to the Chief's prior question the language or hold an office or position of profit. So I'm not only focused on the full time.
That's a loaded question. I think I understand what your honors are both saying.
Well, we may not be saying the same thing.
That's because you added on to his question.
Exactly.
It's an or.
I originally did argue, but there is a comma in there. There is a comma. Justices and judges shall devote full time to their judicial duties, comma, and shall not engage in the practice of law, hold office in a political party or political organizations, or hold an office of position of profit of the government of the United States. In this case, it's a municipal. I don't need to read all of this. It's a state office and a municipal office. It starts out that judges shall devote full time to their judicial duties. This particular judge was working part-time. He's a part-time per diem judge. Not saying it's okay for him to have an outside job, but what it is he was literally just finishing up these cases. The parties asked him, he advised us that we had to finish the case in July. We asked him to elongate the deadlines. He told us that he asked the Supreme Court, AOPC, if he could finish up these conflict cases, and he believed that he was authorized to finish these conflict cases.
This was based on a purported discussion with Joe Middleman at AOPC?
And I forget the woman's name. There was two. He discussed both of them. He discussed it with both of them. But all I'm here is to argue what he understood to be, not what was or was not said. We did not, Chester Upland School District did not have an opportunity to discuss with Mr. Middleman. We were never given an opportunity to probe his statements. But I digress. I think that it does make a difference that he was a part-time per diem judge wrapping up his cases. The trials were complete, and he was just making his final decision based upon our submissions.
So you're saying there was no constitutional violation?
That's not what I'm saying, Your Honor, at all. What I'm saying...
What difference does it make? What difference do any of those qualifiers make? I'm sort of lost.
Because we don't know if it was a violation. Does a violation
Commonwealth
include
Court did.
intent? I don't know. I don't practice in the area of judicial discipline.
Well,
so
the Commonwealth Court, that's
Right.
not this case, and the Commonwealth Court interpreted the Constitution and found that there was a violation here.
Mhm.
I don't know why they can't make that finding. There's a violation of the Constitution here.
I think they can make the finding. I don't think that they can strip Judge Braxton of his judicial authority. That's the difference here. I think they can make that finding, and then they can decide whether or not it impacted the litigants in this
Counsel,
case.
let me ask you, how is that different? How is that different from an adjudication by a court that there was an ultra-virus act by any person? This determination was that there was a violation of the Constitution. So I suppose you would maintain that while a court presumably is empowered to make a constitutional adjudication, it is divested entirely of any power to direct a remedy for that violation, which is striking, number one, and number two would suggest that a court that finds an ultra-virus act in any number of circumstances would be powerless to order a remedy. All these qualifiers about, well, he was part-time, or, well, he made this semi-disclosure, or he didn't mean anything wrong by it, we can grant you all that, but those seem to be arguments that would be made to the JCB why not to prosecute, which is not what we're here about. You want to respond to that?
Yes, Your Honor. So I agree with you that the Commonwealth Court and even a trial court can make a determination whether or not a judicial officer violated Section 17. What I'm saying they cannot do is create a bright-line rule that says that he automatically forfeited his judicial office and he no longer has judicial authority to enter into final orders.
Or actually retroactively. You're actually saying that the court can't retroactively invalidate an otherwise fair and impartial decision made by a judge because of a simple violation. Let me give you an analysis that may help you out. Every judge up here and every judge in the Commonwealth of Pennsylvania is required to take CJE credits. If a judge is non-compliant with the CJE credit, makes a decision, would you contend that that decision should be invalidated?
No, I would not contend that.
And is that not the essence of your argument, that there was no harm, no foul in this case?
I'm sorry, maybe I misunderstood you. You said that if he did not...
You understood him.
That he did, okay, right. That if you did not take your required CGE, then you automatically forfeit your office. Is that what you're saying?
Correct.
I would say that that's not the case.
And would you also agree with me that any decision made while a judge was non-compliant wouldn't necessarily be subject to a collateral attack because of the fact that they were simply non-compliant?
I would agree with that, Your Honor.
But because it's an alleged constitutional violation, this was different. Is that correct?
That is not correct, Your Honor. It is a constitutional – let's submit that he did violate the Constitution. So he violated the Constitution. There's nothing in the Constitution that gives a disappointed litigant the right to a complete retrial.
Well, and the Code of Judicial Conduct is a constitutional code. Article 5 empowers this Court to create the Code of Judicial Conduct. So arguably, every violation of the Code rises to the violation of the Constitution.
It does, Your Honor. As a matter of fact, that's right in Section 17. That is 17B.
Counsel.
Yes.
Over here.
Sorry.
I have to share with you. Your answers are confusing me. What is your ask? You're saying there's a violation. Are you saying, yes, there's a constitutional violation, but the order should stand as is, and let's forget about Commonwealth Court's decision?
I am asking that the Commonwealth Court's ruling, that its bright-line rule that a judicial officer automatically forfeits his judicial office upon a finding of a Section 17 violation cannot stand. That must be overturned, because that usurps this Court and the Court of Judicial Discipline's exclusive authority to determine when a judicial officer is no longer vested with judicial authority. I hope that was clear.
All right.
That's clear.
Does anybody have any other questions? Okay, let's hear from Mr. Byer.
Thank you, Madam Chief Justice. May it please the Court, I am Robert Byer, and I represent the Aplt Prospect Crozer, along with my co-counsel Ryan Monahan. The importance of Article 5, Section 17A as a constitutional value in Pennsylvania becomes manifest when one realizes that this provision was not something that was added to the 1968 Constitution for the first time, not even the 1874 Constitution. This provision has been in every Pennsylvania Constitution since the Constitution of 1776. Now, with respect to the vintage of this provision, it coexisted with a common law doctrine that was recognized in cases, and I think, Justice Dougherty, you were alluding to this in referring to the section as self-executing. The case law had developed that when it comes down to holding constitutionally impermissible positions of this nature, that taking the second position automatically forfeits the first. In Pennsylvania, the DeTurk case from this court in the late 1800s, it was an 1889 case, so held, and that was followed by Commonwealth ex rel. Crow versus Smith from 1942. Fortunately, we don't have too many decisions in this area because these problems do not arise all that frequently. But these provisions are self-executing, and it means that taking an incompatible position vacates the position that the person already had. And in the words of the court in DeTurk, it's an implied resignation of the first position.
Mr. Beyer, though, didn't those cases predated the amendment to the Constitution in Section 18, though?
Those cases predated Section 18, and this is what's significant. Section 18 was not added until the 1968 Constitution. These provisions dealing with forfeiture for misconduct or for filing nominating papers in Section 18 did not come into being until the 1968 Constitution. So we had Section 17 existing in a common law background that it did not displace at the same time as these common law cases. And then Section 18 comes along with the latest amendment in 1968. It was revised again in 1993, but it doesn't displace the common law doctrine, doesn't displace the interpretation of incompatible positions law under the Constitution, including Article 6.
Mr. Beyer, back to Article 17A, could you articulate why it does not matter if the judge devoting full-time devoting their full-time to their judicial duties doesn't matter if it's a senior judge or a commission judge?
Well, in terms of that first clause, I think it has to be read in context with the constitutional authorization of senior judges to take special assignments. But it doesn't eliminate that senior judge's duty to comply with the rest of Section 17A. Otherwise, I mean, the logical consequence of that would be that a senior judge could be serving as mayor or head of a political party. That would be an untenable situation and something that clearly violates the purpose of Article 5, Section 17.
So it matters not?
It matters not that this is a senior judge.
And Mr. Beyer, opposing counsel maintained that, if I understood correctly, that even in the event of a violation, the court is without authority to essentially do anything about it. How do you react to that?
I think that the court has to have the power to hold that, forget about the use of the term forfeiture. I think, Justice Donahue, you were right on the mark, and Justice Weck, in talking about the consequence of a violation of Article 5, Section 17A is to render void a judicial decision that's made by somebody who is in violation of that provision of the Constitution, because that person simply, that's an order that is not supposed to be entered by such a person.
But the forfeiture is for that case, or is it broad?
I think that it can only speak to that case, because that's all
If you
this.
want to go to the broad forfeiture, then you have to go over to the judicial conduct side.
Correct, but there's no way for the Judicial Conduct Board or the Court of Judicial Discipline to review an appeal.
No, they're two different things.
Exactly.
Well, but Mr. Byer, though, I mean, I'm going to push back with you a little bit on this, because it seems to me that what the opposing counsel is arguing is not that, you can't raise this. Okay, so you're raising, I appeal, why? He violated Section 17A of the Constitution. Okay, he violated Section 17A of the Constitution. The question then is, how did that impact you? What right did you have to a judge that was not violating Section 17A, let alone some other provision of the Code of Judicial Conduct? Justice McCaffrey said a judge who is compliant with CJEs, a judge who's filed a statement of financial interest, a judge who didn't attend a political event the week of your trial. Let's say a judge attended a Democratic Party event the week of your trial during, not during a retention election. Do you get to raise all those just blanket without showing a harm and somehow get relief?
Well, I think that Judge Levitt's opinion in the Commonwealth Court summed it up well when the court said that a litigant has the right to have an adjudication by a qualified jurist, that somebody has to be qualified and able to exercise judicial power in order to render a valid adjudication. That seems to be a very basic due process right that any litigant has. And by violating Article 5, Section 17A, in light of the common law, that involves an implied resignation of the judicial position.
Well, and this is where the rubber hits the road, right?
Yes.
Because that's when you get to 18, which even applying 18, even if you assume a 17A violation, under Section 18, the jurist does not forfeit judicial office for a violation of 17A until they've been charged and convicted, for lack of a better word, by the Court of Judicial Discipline.
Well, that's dealing with a charge against an individual jurist. It doesn't go to the question of the validity of the order entered by that jurist.
I agree with you, but your point is, your answer to the question was, Judge Levitt says you're entitled to have a decision by a jurist that had judicial authority, did not forfeit the office,
and was validly exercising that authority at the time.
Correct, but even under Section 18, everything a jurist could be violating Section 17A and go through the Court of Judicial Discipline process, and the Court of Judicial Discipline says, yes, you are violating Section 17A, you forfeit your office. It doesn't that's the date of forfeit of office under 18. So Judge Levitt basically added, in order for you to win, I think, you have to say that the common law survived the amendment of Section 18 to the Constitution.
That's correct, Your Honor. The common law does survive, and that is our position.
Isn't another way of looking at it, Mr. Byer, that we're dealing here in two distinct paradigms within the same article, so that just like if somebody hits me over the head with a club, I can sue them civilly for assault, and the Commonwealth can bring a crimes code case against them for assault. And these are vindicating different interests. So the interest of the JCB in vindicating the public with respect to the Code of Judicial Conduct is one thing, and the Article 17 issue that's present in this case is an entirely different paradigm. It's the civil justice paradigm in which you and your opponent were engaged in litigating here. But the hang-up maybe in this case is this use of the term forfeiture or removal.
Yeah. Well, that's been my point from the beginning.
And the issue is, it seems to me, is rather, was by virtue of Section 17, was this judge disempowered or judicially constitutionally disabled from exercising the judicial power? Isn't that the way to look at it?
Or
yes, Your
was
Honor.
the order simply void ab initio because of his staff?
The order is void, yes. And this is.
Can I just clarify one other thing here? And in getting back to the Mr. JCBE credits, head up a political party, there's no common law to analyze that situation. And that's what really distinguishes what happened here. There's a fulsome body of common law that establishes if you take a job that's incompatible, you're resigning the first job. So if the Commonwealth Court had used the term, this senior jurist resigned from his senior jurist position, and therefore the orders that he entered after that resignation are void.
That's correct.
We wouldn't be talking about forfeiture in any way, shape, or form. This would be an application of the common law to a situation that's come up for centuries in this Commonwealth.
That is precisely right, Your Honor. That it's the term forfeiture that I would not get hung up on that. It's the consequence of what the violation of Section 17 was in this case.
Well, I mean, that's a way to get around it, I guess. I mean, because again, the problem is if you stick with the forfeiture paradigm, then it divests, a finding by the Commonwealth Court that he forfeited office preempts the Court of Judicial Discipline, the so-called criminal process, quasi-criminal prosecution. The judge has already been found guilty of violating Section 17 without the process that he was entitled to under the Constitution.
I think the term forfeiture, as used in Judge Levitt's opinion, is a shorthand way of saying that he did not have the right to exercise judicial authority because of his violation of Article 5, Section 17.
Because he resigned that position when he took the job with the Philadelphia Tax Board.
As a matter of law, he is held to have resigned his position because he could not wear both hats at the same time. And it's having taken that second job, the first one is gone. And so I agree with that. And the consequence of invalidation of an order under those circumstances is similar to a number of other cases. The Nguyen case, for example, in the United States Supreme Court, where you had a judge serving without commission as part of a three-judge panel on the Ninth Circuit. And the U.S. Supreme Court said that's a structural error. The decisions cannot stand from that panel.
Counsel, do I understand your response to Justice Donoghue being that Judge Braxton de facto resigned his judicial position by accepting the Board of Revision and Tax?
If you call it, you can call it de facto resigned, or in the case law, it's an implicit resignation. But by accepting the second position with the Board of Revision of Taxes, that he resigns his commission as a judge. Similar to what this Court held in Simmons versus Tucker in 1971, where the Court indicated that if Judge McCune in that case had taken his oath, he would have resigned as a judge of the Court of Common Pleas, at a date prior to the date that the state had determined. But there he had not taken his oath. Here, Judge Braxton had to have taken an oath because he was getting his paycheck. So,
Counsel, is it your recommendation or request to remand this back?
Our request is that the Commonwealth Court decision be affirmed, and then the Commonwealth Court, as part of that, the Commonwealth Court has remanded for further consideration in the trial court.
And this decision doesn't affect any other case that the senior judge in this case adjudicated?
Not involving other parties, no. There are three.
But I meant that really as a matter of law. Unless
Right.
somebody appealed on this issue, those cases are done and finished.
That's correct, Your Honor.
Which is interesting because when I was thinking about the structural error issue here, which we didn't really talk about, in the Luzerne County juvenile justice scandal, that opened up all the cases. So this is not that, I guess you're saying.
It would not,
albeit that it's structural.
It would not open it necessarily, but I think you'd have to see what the allegations are.
Well, and that was a JCB-CJD determination that ended up opening up all the cases, not a case brought by a party in a separate action.
And we were dealing with criminal cases involving juveniles there, and under.
I only sort of, the Chief is right. I just sort of was spinning through that a little in my mind because of the structural error issue in this case.
Do we have to call it a structural error? Can't we just say, assuming, we agree ultimately with what happened here. Can't we just say, given the resignation of the position as judge, he was out authority to enter the order, period?
You could.
I mean, does it really fit into the structural error paradigm as we generally use that?
I think it does. I can't think of a more fundamental structural error than having somebody sitting as a judge who is implicitly resigned the position.
But counsel, if we call it a structural error, how can we not invalidate every order he issued since he accepted the position with the BRT? That's the point. If it's a structural error, you're basically saying that every single order that Judge Braxton executed after the point he took the BRT appointment needs to be invalidated.
Well, it would be.
We can debate the CJD and we can debate the Court of Judicial Discipline, but we're the Supreme Court of Pennsylvania. If we're declaring this to be a structural error, don't we have to, by law, invalidate every decision and every order he executed?
I think a litigant has to have filed a timely appeal to take advantage of that.
Unless it comes through the CJD, right? Because the CJD can do that. Or the Supreme Court could do that, but we would do it as a result of disciplinary proceedings below, not in a particular.
There weren't a lot. Judge Braxton was finishing up. There weren't a lot of orders. Was this the only case he had left at the time he took the job?
I think these were the only cases in Delaware County. I think there was a case in Carbon County that somebody has referred to in the record. Those are the only two that I'm aware of. So we're not talking about a situation even anywhere akin to what happened in Luzerne County.
Do you want to wrap up, Mr. Beyer, or perhaps you already have?
I think I have, Your Honors. We request that the judgment be affirmed. Thank you.
Thank you. Thank you both. Well argued. Want to call the next case, Mr. Minner?
Circle of Seasons Charter School versus Northwestern Lehigh School District. Representing the school district, Mr. Jonathan Huerta. Representing Circle of Seasons, Mr. Mark Bradshaw.
In this appeal by allowance, we consider whether a charter school failed to exhaust its statutory remedies under the tax assessment law before filing a complaint against the school district challenging the taxable status of its properties for the 2017 and 2018 tax years. It's always great to end the day with a tax case.
I always hope for it.
I love taxes.
Live for it.
Thank you, Chief Justice. I actually was considering, in honor of what you started out today with, is the recitation of the history of arguments, that maybe we should reconvene at an ale house, right, to finish up this last.
If we determine it's a matter for the lower courts, we'll do that.
That's right.
How do you know we're not doing that?
Chief Justice, thank you. Justices, thank you. May it please the Court. Jonathan Huerta on behalf of the Northwestern Lehigh School District. This case is a case involving a charter school that just wants the rules not to apply. They've ignored a change in assessment, tax bills, reminder notices, and blew by statutory deadlines, and are now coming back to the school district to ask for school district, which this Court has ruled, school districts are underfunded by the state, to come up with $250,000 to refund them for taxes that they paid. The trial court correctly ruled that the failure to exhaust its administrative remedies by filing an appeal before the Board of Assessment thereby waived subject matter jurisdiction. The Commonwealth Court erred by going a different way. What the Commonwealth Court did correctly, though, is that they in line with the case law, they ruled that it's clear that the statutory remedy to appeal to the Board of Assessment is the mandatory and exclusive remedy. The Commonwealth Court agreed with that, and so they dismissed Circle of Seasons tax refund law claims. That should have ended the question, right? This Court has already ruled in Lincoln, which has also been followed by the Commonwealth Court in Locust and Lutz, that the
Counsel, can I just slow you down for a little bit?
Sure.
Okay. This is a case that this case, we're talking about this one right here, started when the charter school filed a refund action under the refund law in the Court of Common Pleas, correct?
Yes, sir.
And the issue was the refund law allows you to seek a refund for a tax that has been unlawfully collected, or a tax, I forget the language, is a tax to which the municipality is not entitled to collect, right? The problem here, at least as you raised with the Common Pleas Court, and the Common Pleas Court accepted, is for the years that they were seeking, the assessment on which the tax was based was not challenged, was not changed, correct?
Yes, sir.
And you said, we haven't been adjudicated not to have properly collected the tax, therefore you're not entitled to a refund. The charter school tries to say, but the assessment is wrong. Trial court says, no, 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 no. Your Refund Act claim is gone. If you want to challenge the assessment and then get a refund, go through the County Board of Assessment. Am I right so far?
Yes, sir.
Okay. They go to Commonwealth Court. Commonwealth Court says, trial court got it completely right, 100% right. But the Commonwealth Court then nonetheless affirmed the dismissal, but remanded with direction that they transfer the Refund Act claim to the Board of Assessment Appeals. Am I still there?
That's not how I read it, Your Honor. I read that they dismissed the tax refund law claims and instead used the doctrine of nunc pro tunc to essentially argue that there was a breakdown in the administrative process at the Board of Assessment because of an alleged facial defect on the notices. And because of that under the statutory general concept, both the general assessment law and the consolidated county assessment law, that reopened the window because I believe it's 8845.
But the way they affected that was a transfer directive.
Correct, Your Honor.
As if it had been filed, as if the refund action had been filed in the wrong tribunal.
That's correct, Your Honor.
Right? That's mechanically how it happened.
Yes, sir.
That's the part I wanted to focus on real quickly. How can you transfer an act under the Refund Act? How is that filed in the wrong tribunal?
I don't think you can. And I think the Commonwealth Court, what they did was transfer, I think they recharacterized the claim as not a tax refund act, but a challenge of an assessment challenge, an assessment appeal. And they then transferred an assessment appeal that Circle of Seasons never filed back to the Board of Assessment. I agree. I do not think you can transfer a tax refund law matter to the Board of Assessment. Frankly, the very language in the tax refund law states that it can't, one, the case law says it can't be used collaterally to attack assessments, and two, the statute provides that where there is an alternative remedy under the law, which in this case would be the assessment law, it cannot be used. So I do not believe the tribunal, the Board of Assessment, is the proper tribunal for a tax refund law claim. So the Commonwealth Court, that should have been the end of the question. I believe this Supreme Court has ruled that the failure to file an assessment appeal strips the jurisdiction from both the trial and the appellate courts. It's a subject matter jurisdiction issue. What opposing counsel in Circle of Seasons will try to do is revive their tax refund law claim by saying that they are immune. They were an immune entity or a presumption of exemption. They kind of go back and forth. And for a number of reasons, I don't think that a charter school would be provided immunity. Under the Friends of PA Leadership case, which this court ruled that the portion of the charter school law that provides charter schools exemption and had a retroactive component, that the retroactive component was in violation of the separations doctrine. Chief Justice Todd joined a concurrence, and there was two concurrences, both agreeing with the decision, but Chief Justice Todd joined a concurrence that relied more on the unity argument, that to allow retroactivity would treat charter schools differently, would treat charter schools that had filed an appeal before that statute was in place differently than charter schools that did not file an appeal before that statute was in place. So I think Friends of PA Leadership can be used to establish that charter schools were not immune. If they were immune, you never would have needed the exemption language. You never would have needed that challenge. The Bucks County Community College case is also instructive. It's the Commonwealth Court case, and the Commonwealth Court reviewed the community colleges and said that they are local agencies, not instrumentalities of the Commonwealth, and therefore they're not entitled to sovereign immunity. The argument, they reviewed the creating statutes for the community colleges. They also reviewed at the end of the day, who's their creator. And so, similar to a community college, a charter school gets their funding through the local school district. They are created through the local school district. The creating statute of charter schools specifically provides that while they are public schools, which, by the way, Community College Act also provides that they're public colleges, it provides that they are subject to be sued in the same manner as local agencies. The language local agency is specifically in the charter school law. It also indicates that debt incurred by a charter school cannot impose liability on the Commonwealth. I believe all those factors within the charter school law make it clear that they are not an instrumentality of the Commonwealth. They're not entitled to immunity, nor are they entitled to a presumption of exemption. The charter school law in the exemption statute very clearly says that once a charter school has demonstrated that it is using the property for purposes consistent with the charter school law. So in that, they've already placed an initial burden on the charter school to prove that they are using the property in a particular manner. So I believe, yes, sir.
They not purchased the property under their name, Circle of Seasons Charter School?
They did, Your Honor.
So was that not sufficient proof that they're a charter school?
I don't believe it is, Your Honor, and here's why. Charter schools have to go through obviously, obtain a charter from the local district in the first instance. Part of that review of a charter is understanding where they're going to be housed. So it's very easy to understand, to think that a charter school could purchase a property before it has its charter in place, because they're purchasing the property so that they can begin charter school activities there. So a charter school, just by the purchasing of the property, may not have its charter in place yet. I think the next step is to prove that not only do they have the charter in place, but that they are actually, educating students. Additionally, I think that robs a due process component from taxing authorities, because let's consider a church that everybody knows it's a church that's regularly in the process of worship. That in and of itself, you can't, I was liking it to judicial notice. I don't think a board of assessment can take judicial notice that everybody knows that church is operating a church there. I think there still needs to be the action of filing for exemption and proving that the worship is taking place, or that the charter is in place, or that they are educating students in accordance with the charter school law.
Well, you knew it was a charter school. You granted their charter in 2013. And then in 2016, you renewed the charter for 5 years. So there wasn't any question in your client's mind that this was a charter school, was there?
That's correct, Justice Mundy, and thank you for that question. I think this still gets back to, the rule in Dillon's case, the rule of, frankly, they brought up, opposing counsel has brought up the issue of an ultra-virus act. I would submit that a school district, summarily because of their knowledge, ruling that a charter school is entitled to exemption despite its existence on the assessment rolls, would be an ultra-virus act. That is not within our purview. That is not what we are tasked to do. We are not empowered to make decisions as to whether a property is exempt or not exempt. We have to take the assessment rolls as we receive them from the Board of Assessment.
Any other questions? Okay, thank you.
Can I close up?
Do you want?
Just very briefly, Your Honor, if I may. Nunc-pro-tunc, I think there's a lot of case law that establishes that the nunc-pro-tunc relief would not be afforded. They did not act diligently. They waited over a year to finally file for appeal. They paid the taxes, which I think there's case law that establishes that the payment of taxes waives any notice defects. And in its simplest, most logical terms, Your Honor, of the parties that were involved, the school district, the taxpayer, and the Board of Assessment, the school district was in the lowest position. They're the least culpable in this scenario, and they're in the lowest position to have made a change, because they couldn't have deemed it anything other than taxable. And you'll hear a comment that the district is receiving a windfall. I think nothing could be further from the truth. If anything, we're trying to protect our taxpayers' base.
Thank you, Mr. Huerta.
Thank you.
Mr. Bradshaw?
Good afternoon, Madam Chief Justice, members of the court. My name is Mark Bradshaw. I'm with Stevens & Lee, and I represent Circle of Seasons. Justice Mundy, you put your finger on this very clearly, and that is that there is no doubt that the sponsoring school district, if you will, knew that Circle of Seasons was in fact a charter school. And so with all regard to Mr. Huerta, it is not the case that we are suggesting that the school district should second-guess the assessment. What we are suggesting is that when the school district becomes aware that taxes have been collected from an exempt entity that it itself granted a charter to, and a lawsuit is filed, in fact, even before the lawsuit is filed, a demand was made upon the school district that this was a mistake, an error was made, and we are asking for a refund.
But did you ever apply for exemption?
Sorry?
Did you ever apply for exemption?
Well, That is
Isn't the burden on the actual entity itself to seek a tax exemption from the school board as opposed to the other way around? I mean, you're saying school board should have known we're tax exempt and never really sent us a bill, but doesn't the law say that you have to apply for a tax exemption?
No, the law actually is not that clear on this point, and there are a number of decisions that I'd like to focus the Court's attention on that get into that issue. And no, we are not claiming immunity, but we are claiming exemption. And the question then becomes, and this is a somewhat nettlesome question, I will concede, is the exemption self-effectuating?
Self-effectuating?
Self-effectuating. What steps, if any, would an exempt entity need to take to preserve the exemption, and whose burden is it, anyway, if you will? Is it the taxing authority that needs to establish that this is a taxable entity, or is it the party that is claiming the exemption?
Well, hasn't that always, I'm sorry, Justice Recht, hasn't that always been the case that the party would have to apply for a tax exemption?
Not necessarily. There's a line of case law beginning with the Wellsboro case from 1994, moving forward to the Granville Township case in 2006, Norwegian Township versus Schuylkill County case in 2013, all of which talk about a presumption of exemption. And so I have read all these cases, and candidly, I don't understand how the shifting, if there is a shifting burden of proof, if there is a burden of proof initially on the taxpayer, even calling it a taxpayer is inappropriate because they're an exempt
But here,
entity.
I thought the record was clear that the school ignored tax notices that were sent and delayed seeking an administrative hearing. It seems like your client wants that it's your client that wants the windfall, that it wants to extract funds from the public coffers when it's slept on its rights. And that would, among other things, set a troubling precedent, wouldn't it, that we're dealing with the public fisc here?
Well, there is a troubling precedent to be set, and if I may, I'd like to turn your question slightly. The troubling precedent to be set is that one public body would tax another public body. The event that the trial court seized on, and the trial court's decision, by the way, is internally inconsistent in at least two respects. First of all, the trial court found that there was no date on the original notice of assessment. And the case law is absolutely clear that if there is no date, there is no triggering event, and talking about being too late to bring a challenge is meaningless because the clock never starts.
That's for an appeal.
Correct.
The trial court found that there was no date on the notice, which is, I can have an issue with notices with regards to service under the particular subsection, but all that said was that there was no notice on the appeal itself. It didn't say anything about actual notice because your client received actual notice because a year later it refinanced its debt and paid the taxes at the table. So they had actual notice that they were being taxed.
Actual notice in this instance is not what is the driver, because the question is, when is the appeal due? And what the law says is if there's no date on the notice, then the appeal is not due.
Yeah, but you can always seek an exemption by a certain date every year. The taxing authority and that.
Well, and that's what you really have to get into the chronology of this case to understand just how bizarre what happened here is. So the school district was found taxable effective January 1st, 2018. The first payment that was made was for the 2017 tax year, which makes absolutely no sense.
I'm sorry, when you said it was found taxable, what do you mean?
Well, the change in assessment was effective January 18th, according to the undated notice. But the taxes that were first collected were for the 2017.
That's the date of your purchase. You bought the property, your client bought the property in May 2017.
Correct.
And then he got a tax bill for 17-18.
Well, what had happened was that the tax bill had already been issued, and so the settlement agent found that there were outstanding taxes when they went to do a refi on the property and paid them.
Yeah, but you didn't seek a refund for that year. Your refund action that you filed, that might have been a valid refund action in the common pleas court because the municipality collected taxes to which they were not entitled because for that year the property was exempt.
Precisely.
But your refund, we're here because of this refund action that you filed that didn't address the year where there was an actual exemption.
No. The complaint for the refund action very clearly sought refunds for the 2017-2018 year and the 2018-2019 year. And it was filed in 2019, and under the refund law, there is a 3-year statute of limitations. So there is no question that this was a timely refund question.
Well, counsel, can I just go back to this defect in the notice because it didn't indicate the date of the sent, which is required by statute, but the notice did include a date certain as to when the appeal had to be filed.
That's true, and Commonwealth Court held that that was not a substitute for having a date on the notice, that having a date on the notice is a requirement under the statute, and there was no date. So what I really want to focus on—
You can't claim prejudice from there not being a date on it. You can't say we didn't know when the appeal was due because the notice itself told you precisely what the date certain was for filing the appeal.
I understand that argument. That is not the way the Commonwealth Court treated the issue. What I really want to focus on is the idea that there was a failure to exhaust administrative remedies. And the first point that I want to make there harkens back to something that Judge Wecht pointed out in the last case, which is, does it make sense to talk about having a right without a remedy? And in this case, we have a statutory exemption, which I would characterize as the right, and yet we are being told that there is no remedy, even though there is a tax refund law that says that if you have paid money inappropriately and it has been collected inappropriately, you have a right under the tax refund law to seek a refund.
Would you have had to seek nunc-pro-tunc relief in the trial court?
Well, we in effect we did, and I understand that's an issue that's been raised. What we argued was a breakdown in the system, by virtue of the fact that the initial notice was undated.
And that was argued when? At what point did you bring that claim?
It's in the complaint, and it was also argued both below at the trial court level and at the Commonwealth Court level. And so the Commonwealth Court level, at the Commonwealth Court level, Judge Levitt seized on the idea that we argued that there was a breakdown in the system and said the appropriate thing to do is to send this to the Board of Assessment Appeals. Now, let me come back to that, because this is really the nub of the case, it seems to me. So the tax refund law says that you have a right to recover taxes that shouldn't have been paid but were, unless there is an administrative remedy. Well, the administrative remedy here is inapplicable for a number of different reasons. And the first reason is that we did pursue an administrative remedy. We did challenge on an annual basis the 2018 taxes, and in fact the Board of Assessment Appeals agreed with us that we were exempt. So if you'll pardon me, the suggestion, although we'll certainly take whatever relief we can get, the Commonwealth Court suggested that the matter should be remanded to the trial court with instructions to send it to the board.
Well, didn't you have to seek exempt status in front of the board at the beginning of the
And we did.
In front of the board?
In front of the board, and the board granted the exempt status, but what it did not do was it did not reach back and address the prior year.
That's because you didn't ask them to. At that point in time, you didn't ask them to.
Well, that is unfortunately true.
Well, I mean, that's twice. I mean, there was a missed opportunity before this, and then you actually get relief for a particular tax year, but you didn't ask for any retroactive relief at that point in time.
Well, and that certainly was an oversight, and it's regrettable. But the point is that this is an exempt entity, and the board heard that claim and agreed that it is, in fact, an exempt entity.
There's a consequence in public taxation for that unfortunate, regrettable thing you just conceded to, right?
Well, not given the tax refund law. The tax refund law gives a right to someone who has improperly paid a tax to seek a recovery of that tax within 3 years.
Well, but that's the question. First of all, whether an entity is immune, property is exempt. So the exemption is for the property, right? So that sort of is where you are in terms of your analysis. Is at the time for the tax years you sought a refund in your refund action, were the taxes when they collected them properly collected?
No.
Well, you're arguing that, but if they were on the tax rolls and taxable because your client didn't get an exemption determination for that particular year, then the school district presumptively acted properly in collecting the tax. They were entitled to collect taxes that were on the rolls as taxable.
Right, but the question becomes, was the property taxable at all?
No, I know you want to make that the question, but that determination about whether a property is taxable at all is made by the Board of Assessment. It's not made by the Court of Common Pleas. Court of Common Pleas doesn't determine whether properties are tax exempt or not unless it's an appeal from a Board Assessment determination.
Correct.
You tried to turn a refund action into a tax exemption request.
Well, and essentially what the Commonwealth Court did, this is my analysis, not taken straight from the opinion, but if you'll humor me, what the Commonwealth Court did was to say, before the refund request can be entertained, there is this issue of exhaustion of administrative remedies. So step one is to go back to the board, and I would argue that the board's already heard this case and has agreed that there is an exemption that's appropriate because it is, after all, the charter school. But what the Commonwealth Court did was to say, step one is back to the board, then once the exemption is confirmed, would be my term, then you would go forward with the tax refund action. But the craziness behind this entire thing is that we are now spending all this time and effort in litigation between two public entities arguing about their ability to tax each other, which the case law has said over the years makes absolutely no sense.
But you're having an argument with the wrong entity. You're supposed to be having the argument with the Board of Assessment Appeals. And this is where I think the Commonwealth Court got super creative, and you don't want to talk about this, but this is what the Commonwealth Court did. Basically, they affirmed everything. They said the Common Pleas Court, you're absolutely right on everything, but then they did this. We're nonetheless going to reverse the dismissal and remand to the trial court with instruction that it transfer this matter, meaning your refund action, to the appeals board to consider the merits of your challenge to the county assessment notices and the school district taxes involved in charter school properties. The transfer notion applies when a matter has been improperly filed in one tribunal, you can transfer it to the proper tribunal. How is this, even if you're right that that's what they did, how is this mechanism that the Commonwealth Court put in place consistent with the judicial code and the jurisdiction of the trial court and the Board of Assessment Appeals?
Well, there is a case in controversy that was filed in the trial court. The Commonwealth Court concluded that there was a necessary precondition, specifically that there be action by the board to confirm the tax exemption. And so it essentially said, let's reorder this and stack it appropriately. Let's start at the board level. Let's confirm the exemption. Once you've done that, presumably that also takes the purported administrative exhaustion issue off the table, and then you proceed with your tax refund.
But even under that paradigm, that's not what happens, right? Because what happens under the board assessment law, the county assessment law, is you would have your proceeding in front of the Board of Assessment Appeals, and then you'd have an appeal to the Commonwealth Court, to the Common Pleas Court. You wouldn't have a refund action under the state refund law.
The difficulty that I perceive in where we are at this juncture is that returning us to the board, and this gets to the concept that there needs to be exhaustion of administrative remedies presumes that there is an available and an adequate administrative remedy. And I don't believe that the board at any juncture, not now, not earlier, would have been in a position to direct the school district to make a refund. As I understand the board's jurisdiction, it determines that a property is either taxable or it's not taxable, and if it's taxable, then it determines the extent of the tax, the amount. And so where taxes had been inappropriately paid, I don't see how returning us to the board actually accomplishes much other than possibly crossing off the line item with respect to the potential exhaustion of administrative remedies. But I don't think the administrative remedy is adequate because the board can't grant relief on the tax refund claim.
But you're presuming that new pro-tunk relief was appropriate here. I mean, you know, your argument is it wouldn't make any sense to do it any other way. We're entitled to relief. But, I mean, what the Commonwealth Court here did was just sort of create a filing that you never made and treated it as though it were transferring something that was filed to an appropriate venue, and that's just not what happened here.
We clearly had argued that these taxes should not have been collected, and we also clearly had argued in the complaint that by virtue of the fact that there was no date on the notice, that there was no timeliness issue at all. And so what the Commonwealth Court did essentially was to agree with us on that point and to say, since you were never out of time, your remedy, if there is no date on the notice, is a hearing before the board. That's what the statute says. That's what we're going to afford you.
I think we understand your position. This case is making Justice Brobson nostalgic for his days on Commonwealth Court.
Love a good tax case.
Being the last person at the podium on any given day is a real challenge, and so that will encourage my brevity. Thank you.
Thank you. Thank you. Mr. Minner?